Hello, test, hello, test.
Or
Folks, you hear me?
yeah, he's remote. We're gonna
Yeah,
put
we
more
can
room.
hear you.
Yes, they just removed it.
Morning, Ed. Can you hear me?
I certainly can. Good morning.
Great. Okay, we can go ahead and get started.
So let's call this meeting of the Maine Human Rights Commission to order, and we'll start with the business section, and then I'll read the introduction for the hearing and case agenda. Kit?
Okay, so we need a motion to adopt the agenda and consent agenda first.
No
So
amendments?
No amendments, nope.
second,
Okay, so the commission's remote participation policy requires that the commissioners indicate their votes both visually and audibly. If you vote yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
And next, a motion to adopt the May 2026 commission meeting minutes.
So moved. Second,
Any discussion? Being none, Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas.
yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
Okay, and for directors' reports, we've no changed personnel so far. Although hopefully next meeting I'll have some new folks to see about. For compliance, we have 3 cases in active conciliation, 2 successful and 1 unsuccessful. And I need a motion to fully dismiss cases H21-0257C and E18-0503. Those cases have completed all of the terms of their conciliation agreements. The reason they're sold is sometimes it takes a while for us to track folks down to confirm that that has happened. So those are done, and we also need a motion to approve the agreements in H25-0366 and E24-002. I'd like to do all of that in one motion. I think that's fine.
So moved as to all.
Thank you, Commissioner Douglas.
Second,
Thank you. Any discussion?
Kit, what's the notation of litigation in that Carey case? What does that mean? Just in the way you've described the title, motion to dismiss conciliation litigation. Does that mean it was in litigation or?
Since it was a reasonable grounds housing case, probably there was a complaint filed. And then we discussed settlement with the parties and never actually went forward with the court complaint. That would be my guess. Remember Angela Carey's case.
Thanks.
Oh, Angela Carey's case we settled.
Yeah. And so, no, yeah, so this was, there was a settlement after we filed the court complaint, and they have now complied with all of those terms. So we're
Right.
done. Okay, any other discussion? None. If you were in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas,
yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
Okay. For investigation, we had 44 new complaints in June with a total of 61 respondents, 35 cases administratively dismissed, 15 right to sue requests. And for predetermination settlements, we had 9 withdrawals with benefits, 2 settled while they were in investigation, 2 settled through the commission's mediation program, and 5 settled privately for a total of $253,500 to complainants. We had 1 withdrawal with no benefits. Litigation, we would take an executive session. No new business.
Kit?
Yeah,
In the case activity summary, I was just wondering if your form would easily allow a little more history, like prior month or year to date or something, just to know whether it's going up or down. This seems, I think this is dead normal, isn't it? 44 cases?
yeah. I can ask Michael. Michael is the one who puts these together.
Yeah.
And he is sort of a whiz kid with Excel, so probably he can do that. Let me make a note to myself to ask
Yeah, I
about
think
that. He's out.
I'd sort of like to see a little bit of context of how our cases are going.
Sure. Any other questions, requests, thoughts?
So there's two other conciliations in the list that say signature. Oh, that's for us to sign or discuss in executive session or what?
In conciliation?
Yeah, E24-21 conciliation agreement. Yeah,
Yeah, you
those
just-
are.
You just voted to approve the agreements in those two, so I will sign them.
Oh, I see. They do repeat the other ones. I thought they were different cases. Just in the list that's displayed in the OneDrive. Yeah, okay. No problem.
Okay. Are you in OneDrive, Ed, or are you in Google Drive?
I'm sorry, I'm in the Google.
Okay, just because we haven't updated the OneDrive for a while, so that might not be.
No, I'm in the Google Drive, and that works
Okay.
seamlessly and perfectly. Yeah.
Yeah, there's a conciliation status memo that has all of them, and then there's a list of memos from Jane and also the conciliation agreements. So some of those, anything to approve a conciliation agreement and any conciliation agreement will also be on the conciliation status memo.
Okay.
Anything else? Okay. Should we be in recess until 8:45?
Did we approve the minutes of May 18th?
Yes.
We did. Okay. Yes, fine. We'll be in recess. I've got 8:37 on the computer clock until 8:45. We have a long agenda and we'll start promptly.
Great.
Hello?
Hello? Hi, guys. I love you so much.
Good morning. We are not hearing cases yet. We will be in session at 8:45. we've muted ourselves and we've muted everybody else until that time.
I understand. Sorry.
All right. You're muted, Ed.
Thank you. Yes, we'll get started. I just want to say good morning to my fellow commissioners. I hope you guys aren't too hot down there. It's a little cool down here, but I'm watching the ocean constantly for you, and it's in good shape.
Thank you.
Motion to sanction.
Good morning. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas online, including the consent agenda available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission will vote on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments in the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments out of the 10 minutes, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one, relevant factual errors; two, relevant omissions from the report of facts submitted during the investigation; three, relevant issues and questions concerning interpretation of law. The commission allows parties who do not disagree with the investigator's report to rebut arguments made by the opposing party. Please be advised that commissioners may ask questions, and I'll ask that you introduce yourself as you're recognized for your argument. The hearing agenda begins with the first case, E240151, Eric Gordon versus State of Maine. The recommendation is that the commission find no reasonable grounds, and therefore we will hear first in order of argument from complainant.
Before we begin, I would just remind everyone that the Maine Human Rights Act's confidentiality provisions, as well as the Commission's procedural rules, require that we not use the names of any person or entity who is not a named party to the complaint. Those people and entities have been given pseudonyms in the report, so we ask that you either use those for consistency or just use someone's title instead of their names. I will pause your time and remind you if necessary, and I'll do another reminder of that every few cases just so we keep it top of mind. Mr. Gordon, good morning. You have
good morning. Oh, sorry.
That's okay. You have 10 minutes total. Do you want to save any of that time to respond to the state after they make their presentation?
Yes, I would like to save a few of the minutes there, at least 5 probably, to respond.
Okay, I will start you off with 5 minutes. So we'll do your 5 minutes, then the commissioners may ask you questions, and then the state will present, and then we'll come back to you for the other 5 minutes.
Thank you.
All right.
Well, just let me know when to begin, I guess.
Whenever you're ready, go ahead.
Okay, great. Thank you. So as outlined, I think there's 3 primary complaints here. One is a performance improvement plan and the care for my child that's mentioned in there, and my lack thereof to be able to care for children while I'm working, despite the fact that coworkers and employees are able to do so, provided that they are female and or depending on the age of their child. The next deals with another supervisor and retaliation that has occurred after filing what I had believed to be a protected complaint on behalf of other employees as a supervisor. She did, pursue retaliation at a very high level. I did submit a list of 17 witnesses, which I believed were going to be questioned as a form of my evidence. Many of them were afraid to even write a letter or submit a letter because of the retaliatory nature of the supervisor at hand. None of those witnesses were interviewed. 0 of those witnesses were interviewed. I do believe that would have provided substantial evidence of retaliation at that particular point, as many of them had first-hand knowledge of things she had said and things she had done to make my performance appear worse than it is. And then the third is the away message, out of office message that what I was written up for while using family medical leave. Again, I think it's relevant that the away message that had been put in place was one that I had used prior and had used for long weekends, vacations, things of that nature, and had never been told that that was an incorrect away message. She provided away message guidance while I was on my family medical leave, during the middle of the family medical leave, and has not followed it herself or enforced it among other employees prior to this, either before or after this. And so I do believe there is reasonable grounds on a number of these. And I would like to say that any performance issues that have been presented, I think, again, interviewing the 17 witnesses would have allowed folks to know and the investigator to know that these performance issues, in all accounts, are embellished, if not entirely fabricated. And I'll rest there.
Commissioner, questions for Mr. Gordon? Okay, seeing none, you'll have 7 minutes when we come back to you, and next we will hear from Attorney Morrill. Want to save any of your time?
Well, I'll just save 2 minutes. Thank you. Good morning, Commissioners. Kelly Morrill for the Maine CDC. In this case, we have 2 complaints. We have the original complaint. We have an amended complaint. There are 4 supervisors involved here. The first complaint primarily involves supervisors 1 and 2. Mr. Gordon's supervisors changed around September 2024. So the amended complaint applies generally to supervisors 3 and 4, and mostly contains allegations of retaliation. There's a common theme between the 2 complaints, though. Both pairs of supervisors are trying to manage Mr. Gordon's performance, and as a result, he's accusing them of discrimination and retaliation. However, Mr. Gordon's performance was not satisfactory at some points, as shown by the fact that there was a PIP in place under the first 2 supervisors, and then the second 2 supervisors did not put him under a PIP, but they were trying to give him guidance, give him constructive criticism about his performance. And so there were legitimate reasons for the imposition of the PIP and for monitoring and giving him guidance on his performance. With respect to the PIP addressed issues such as time management, preparation, communications. There was a notation in the PIP that he was not to work remotely while he was caring for his children. There was also a notation in the PIP that he was supposed to put an out-of-office message on his email when he was out on leave. That PIP was in place for about a year, and then it was removed with those expectations going forward. When the new supervisors came on board, they identified some of the same issues that were addressed by the PIP. And so his new direct supervisor was trying to address those issues. One of the main contentions of Mr. Gordon here is under the sex discrimination prong, the fact that he expects to be able to work remotely from home while caring for his young children. His statement that other employees were able to do that is false. No employee is allowed to work from home and actively care for their children. The comparators that he's offered up are not similarly situated. At the time, he had a 4-year-old child. Other comparators that he's offered had older children who happened to be in the home at the time and could fend for themselves, basically. Teenagers, they just happened to be there. There were a couple of situations where there were younger children there who appeared on camera at points. Those employees were given guidance, as Mr. Gordon was given, that that's not appropriate when you're working from home. You need to be working and not caring for children. And in those two particular cases where those employees were given guidance, there were other adults in the home caring for the children at the time as well. So the employees were not the primary caregivers. So he has not, Mr. Gordon has not given any examples of any employee who was allowed to actively care for children in the home while they were working. The CDC acknowledges that sometimes when there is a child in the home, there may be some emergency that happens and the employee may need to tend to that emergency. And in those cases, they're expected to take paid time off for that time during the day. The telework policy is pretty clear. The telework policy that was put in place during the pandemic, it does say that, we just get that. I can find it quickly. Okay, guys. I apologize. I can't find it quickly. I'll paraphrase. I mean, the telework policy does say that employees are expected to be working when they're at home. It does acknowledge in the Q&A that if there is a child in the home at the time, that's fine. A child that's older and able to care for themselves, that is allowed under the policy. We do acknowledge that there is not a specific age cutoff in the policy. As the investigator acknowledged during this investigation, it's kind of a matter of common sense. If you have a 4-year-old in the home, I think you can conclude that a 4-year-old is going to need, if not constant care, at least attention. You can't just let put a 4-year-old in a room and say, entertain yourself for the day. Whereas high school age, teenagers, even 10 or 12, they're more apt to be able to do that. With respect to the retaliation piece of this, the retaliation piece, I think, is mostly directed at supervisors 3 and 4 under the amended complaint. When the new supervisors came on, as I said, they recognized that there were still some performance issues of the complainant, and this supervisor was trying to help him and guide him. She was reviewing his emails because he had had issues regarding communications in the past. So she was giving him feedback. He took that as harassment. We respectfully disagree. We consider it to be performance management. The investigator also held an issues and resolutions conference in this case. He was able to assess credibility. Supervisor 2, 3, and 4 all testified at the issues and resolutions conference about their management of the complainant. So the investigator was able to assess the credibility of the complainant and the supervisors in this case, and concluded that there was no hostile work environment or discrimination here. With respect to the 17 witnesses that the complainant listed, that list was submitted on the day of the close of evidence in this case. And I would also submit that 17 witnesses who are going to give their subjective opinions on what they think is going on in this case, only having part of the information, really is not probative to whether there was discrimination or retaliation by these supervisors. I will leave it at that, and I'm happy to answer any commissioner questions.
Commissioner Sanders.
Thank you, pretty well. Good morning.
Good morning.
I'm curious about if I bring your attention to page 4 of the investigator's report. There's a letter, paragraph L, discussing the 2025 annual review and the complainant's allegation that review was retaliatory. What I noticed, though, was that the very last sentence in that paragraph reflects that year, actually, the complainant received a merit increase following his review. So can you square that for me? To the extent that he was not performing effectively in his job, how did it come to pass that he was awarded merit increase?
I think he probably got satisfactory reviews in that performance evaluation. He was not under a PIP at that point. The supervisor was still working with him to try to, improve his performance in certain areas. I think generally, unless the performance evaluation is terrible, people generally get, I think, merit increases in state government. I think they generally do. I don't think many supervisors would recommend no merit increase for an employee unless, there was some misconduct or some, really terrible performance and they were like on the verge of being terminated. That's the only way I can square it, I think.
But did those policies, that framework come up as part of this investigation so that we could really understand for the circumstances under which he was granted that?
I don't believe so, no.
Just one other question as well. It's the next paragraph, lettered M. This reflects the disciplinary action that he received as a result of the, return to work auto message that didn't meet expectations. In isolation, my impression in the investigator's report didn't necessarily get at this, so I can certainly ask the investigator, but I'll ask you as well. It seems like a minor infraction, seemingly. Can you tell me more about why wasn't that a minor infraction, especially if we credit the complainant's allegation that this was, the very same message he had put on his email in the past. So what was different and why was it serious enough to garner a disciplinary action?
Well, first I would say the out of office message that he used while he was out on leave was something like, I am out of the office. I will respond to your email when I return, period. No dates, no anticipated date of return, no, you may contact so-and-so in my absence. Just I'll respond when I get back. So nobody who would email him would know what they're supposed to do, especially if they had an urgent situation. Who do I contact? I guess it would respond that was a minor infraction. He got a minor discipline. It was a written warning. It was the lowest form of discipline. Doesn't affect his pay, terms and conditions of employment. It was just, it was a minor discipline to tell him. As a manager, he should have known that was not a sufficient out of office message. When you go out on leave, you don't know when you're coming back.
How would he have known that?
I think it's common sense. For me, it's common sense. I think it's common sense that you at least, even if you don't know when you're coming back, I think you instruct people who they're supposed to contact in your absence, especially if you don't know when you're coming back, because otherwise, what do they do?
Did his supervisor know on FML, is it customary for supervisors to have access to that employee's email account? And so in that way,
No.
That is not consistent with
Supervisors, no, nobody has access to other people's email accounts usually, because everyone has their own password. They have their own email accounts. So supervisors don't get into their subordinates' email accounts.
Elsewhere, that's customary, right? And I'm just curious about the state's practice in that regard.
In state government, no, the supervisors don't get into employees' emails.
All right, thank you.
Yes.
Any other commissioner questions for Attorney Morrill? None, you will have a little over 3 minutes.
Thank you.
Mr. Gordon, you have 7 minutes. If there's anything else you'd like to add?
Yeah, sure. So actually, to the fact that the state is saying that my performance was not satisfactory, that's actually not true. I had received just before the PIP, had received a performance eval then that met expectations. To the point of the commission, I also received another one with a merit increase in 2025 that also met expectations. Before the PIP, had they informed me that my performance wasn't satisfactory, I could have gone back to my previous role at that point. But instead, the only thing that changed in about the month's time from the time that my performance eval happened to the PIP was that I put in my guidance that I was getting ready to take family leave to take care of my child when my child was born. And so that also plays into why they put that in that message, I believe. To the fact that nobody's caring for small children, one of the supervisors in this instance that's named here, in her testimony to the investigator, admitted that she regularly takes care of her children, which at the times of this complaint were 7 and 8 years old, which is far younger than what the state has said is reasonable. So there is no reasonable expectation. It is discriminatory to someone based on familial status. My 4-year-old daughter at the age of 4 was able to complete college level coursework that sometimes was 10 hours a day, right? For 2 days in a row, but yet could not stay home with me for an hour or two until her mom got home, right? And so for me, that is a challenge. The PIP did mention an out of office message, but again, I want to reiterate that I had used that same away message in response to the PIP, and they told me it was okay to use that away message for years. At this point, from the time that the PIP was put in place until I went on this family medical leave, I had used that away message for every instance of absence, and it had never been deemed unsatisfactory. And then there's really no difference between, from an age standpoint in the same categories. They would be attending a similar school, a 7-year-old and a 4-year-old, right? So they're in the same age bracket, but those employees are allowed to do it. Testified that they regularly did it. And then, again, no age qualifications. Those 17 witnesses would have been able to testify to a number of issues, including my supervisor trying to upend contracts that I had in place, trying to prevent me from spending down my money, things that would have deeply impacted my performance. It would have been imperative to interview those 17 witnesses because they would have had firsthand knowledge of those things. They've come to me and said these things, that she's had meetings with them where she's told them, I'm trying to fire him. She's told them, I'm looking to see if I can get the Wabanaki tribes to make a racist remark, even though there wasn't a racist complaint, right? These are things that she has told those 17 witnesses. So it would have been imperative to interview those 17 witnesses to create the body of evidence that I would have needed. Again, the out of office message, there is no contact, there is no guidance given at all prior to me going on family medical leave from supervisors 3 and 4 on away messages, period. I had used the away message that was deemed appropriate from the PIP. I was available to my supervisor via phone and offered to take texts and calls if there were any issues that arose so I could help navigate them. Additionally, the lowest level of discipline was only given because that is the progressive discipline policy, not because they chose to go light on the issue. They went as hard on the issue as they possibly could. And MSCA, our union, is currently grieving both the PIP and the out of office message, both of which they feel like are discriminatory in nature and not with just cause. And I will rest there.
Commissioner, questions for Mr. Gordon? Commissioner Douglas.
Yes, Mr. Gordon, good morning. Do you have the report in front of you, sir? The investigator's report?
I do not have the investigator's report right in front of me. No, I do not.
Okay, so I'm looking at page 3, where the investigator describes her findings of fact. And I guess I'll just read this to you. It says, on February 3, 2023, complainant and director had a conversation on Teams. According to complainant, he was instructed that he had to take leave for his mental health and would be required to take a longer leave if he did not take time off promptly. The chat from Teams reads as follows. This is the part I want you to pay attention to. Director, quote, I am really worried you need some time off to take care of yourself. Have you thought more about taking Friday and Monday off? Unquote. Complainant, quote, my brain is fried. Friday, yes, Monday, no. Unquote. Director, quote, I don't want you working Monday just because of a staff meeting. It is not important. There is nothing major going on that is to be discussed. Your own health is far more important than staff meeting, unquote. My question for you is simply, do you dispute that that's what was actually on that Teams chat?
So it was not a Teams chat where this conversation happened. It was a Teams call. This was in follow-up to that chat. right? And so she had already told me that I needed to take the time off or present the larger body of work or larger body of time off that I would take. So
Okay,
this is in follow-up to that, yes.
Yeah, I just want to know, do you dispute that this exchange happened? That's all.
No, I do not.
Okay. All right. And then in paragraph D, there's a litany of performance issues referenced here. And I'm just going to read them. Time management and task completion, preparation and planning for meetings and projects, and interpersonal skills. And I just want to, in an effort to be fair, you deny that you had issues with respect to any of those areas. Is that correct?
So here's what I would say, and I think this is, in the spirit of self-accountability, right? I think anybody can be better, right? Am I the perfect employee? Probably not, right? Am I a problematic employee? No, right? And I think that to the point that these issues are problems, no, I don't think these issues are problems. Could they have been areas that, like, I think, if I were to sit there and say, could I improve in that area? Probably. Would it have been worthy of a performance improvement plan? No. Were there actual issues? No. And so I do not believe that there were issues in those areas. Rather, they may have been opportunities for growth, as I think there could be a lot of opportunities for growth among any employee, right? If you really want to look critically at it. But I don't believe these were problems, no.
So there was a written performance improvement plan, yes?
There was what?
There was a written performance improvement plan, yes?
Yes, which is at the heart of this, which included not being able to care for children in the performance improvement plan. There were a number of things. Okay, sure. Sorry.
I'm sorry. It's just we have to keep things moving. So yep. I don't have the performance improvement plan in the documents that were provided to me. And I'm just wondering, these issues that we just read off, were they're mentioned in the performance improvement plan, yes?
They were not the end of it, no. There was a lot mentioned in the performance improvement plan, and much of it was unfair.
Okay. You worked off this plan, and at some point it was removed, true?
It was.
All right, thank you.
Any other commissioner questions for Mr. Gordon?
Yes.
Commissioner David?
Mr. Gordon, good morning.
Good morning.
The report indicates that you had a discussion with HR about the complaint about working from home with your child there, and that you understood that they were saying to you that that was not appropriate, correct?
They told me it was inappropriate, correct.
Right. And did you continue to insist that you could and do that?
I did. Did I continue to work
with the child while you were caring for the 4-year-old?
No. They told me it was inappropriate after the PIP. So my conversation with HR came after the PIP, in which I felt like this was discriminatory. We had a conversation about it. Because the PIP says I can't work with my 4-year-old, I did not work with my 4-year-old.
Any other?
Okay, thank you.
Any other questions for Mr. Gordon? Seeing none, we'll come back to respondents. Attorney Morley, you have a little over 3 minutes.
I won't take that long. Just 2 points. The first point is I'm not aware of anything in the record where witnesses testify that they regularly stay home and take care of their children while they're working. We acknowledge that there were children in the home at times when people were working remotely, but nobody has said that they regularly care actively for their children when they're working. The second part of this is that Mr. Gordon's subjective beliefs on how his performance was has no bearing on this analysis. The First Circuit case law says that so long as the employer believes credibly that his performance was lacking, that's what matters here. So there's no evidence of pretext if that's the case. And in this case, the supervisors did believe that his performance needed improvement in several areas, which are outlined in the PIP. and continued on to the second set of supervisors. Happy to answer any questions.
Yeah, Commissioner David.
Yeah.
And then
You said previously that there were 2 supervisors or 3 that testified.
3, the fourth one has left state government, so she did not participate in the Issues and Resolutions Conference.
And so 3 supervisors that were in succession, not at the same time, but over a period of time, there were 3 supervisors. They all testified and they all concurred
Yes.
in the act. Okay, thank you. Was there any other, I'm sorry, was there any other? Well, that was the process of evaluating him, right? What was the process that that respondent went through to come to the conclusion that he needed to be terminated?
Oh, wait, he's still working there. He hasn't been terminated. He's still working.
Oh, he hasn't been terminated.
No, he's still working. He's never really been disciplined other than the written warning for the out of office message.
So the complaint is that he still wants to be able to work from home while he takes care of his child?
That's part of it, yes. He has complied with the directive not to do that, but yes, he's been kind of pushing. I mean, in this complaint, he's been pushing for that. He wants to be able to work from home and take care of his young children. That's part of the sex discrimination claim, yes.
Does he claim any other adverse employment action?
The PIP was part of his argument. He also had claimed that the supervisor 3 has been excessively monitoring and scrutinizing his work, which we would say is just performance management. He also claimed that he was told that he had to take time off for his mental health, which is not the case. So he's claimed a few different things that we would say are not really adverse actions and aren't true anyway. But
Okay.
there are some other things in here.
Thank you.
Okay, so just to follow up on the questions I asked Mr. Gordon, there was a written PIP.
Correct.
Right, and
Yes.
it mentioned performance issues such as the ones mentioned in the investigation.
Correct.
And he signed it? Is
I
that
believe
true?
he did.
Yeah.
I believe he did.
Because I don't have that in front of me.
I don't have it.
I assume it's in the record.
Yes. it's
And
in
then
there.
he worked off the PIP. He worked on the issues mentioned in there. At some point, the PIP was removed.
It was, correct.
The policy, the work at home policy, do we have that language?
Yes, it'll be. Give me a minute. I'm sorry, I don't have it.
Meant to say, last thing up here would be great if you could.
I do have it in here. So I know I cited it. Let's see. You're looking for something, you can't put your hands on it.
we're making excellent time. So
Okay, so the relevant parts here are in our original submission. Teleworking employees are expected to be focused on their work in a dedicated space and must not be responsible for caring for children or others during their scheduled work hours. Time spent taking care of household tasks or personal business is not considered time work. And then there's a Q&A that is attached to the policy. What happens if I don't have reliable dependent care? Will this count as an extraordinary circumstance? No. Employees are expected to have reliable dependent care and should not be actively providing care while working. If a dependent is self-sufficient and happens to be at home while you are teleworking, that is permissible. However, if the dependent requires attention during the day that interferes with your normal schedule, teleworking is not permissible. You'll be expected to use appropriate leave time for any time you are actively providing care while you are scheduled to be teleworking. So that's been in the telework policy since it was enacted, I think in 2022, it looks like.
Thank you.
any other commissioner questions for the respondent? Being done, thank you. All right, we have heard from the parties and next we will hear from the investigator, Bob Boucher.
Morning. And to touch on a couple of points. First of all, the child care situation complainant did allege that he was being treated differently in that regard than female employees. The comparators, however, revealed again, it was either situations where the child was old enough to essentially care for themselves to some extent, and or there were other adults present in those households while the younger children were around. So I didn't find them apt comparators in this case. With respect to the retaliation by his new supervisor, the last of these supervisors, the allegation was that he had complained about her methods and her intensity. Even assuming that that was the case, that certainly did not involve any type of illegal or unsafe workplace activity. He simply didn't like the way she communicated with him. So that could not reasonably be considered protected activity, even if he believed that he was reporting something that might potentially be illegal. With respect to the away message, again, I think that's sort of nuanced discipline in this case. Whether you use the same away message in the past, there's no indication that a supervisor was aware of that or had the opportunity to correct the extent of the message. In this case, again, totally open-ended, I'll contact you when I happen to return. Could be weeks, could be months, could be longer than that. So the idea that he was told to provide some kind of parameter in his message as to how long people could anticipate until they received the reply, again, whether or not it warranted discipline or not, in this case, there's nothing to suggest that that was retaliation for any type of activity in the past, even if he disagreed whether or not it should have warranted discipline. Lastly, just to touch upon the number of witnesses that he offered, complainant was told repeatedly that he could submit a written statement from anybody who wished to participate in this case. So it wasn't a question strictly of the time needed to interview these people, but they had the ability to say whatever they wanted to say and to make it part of the record by submitting a written statement. Some did, others did not. But again, there was nothing in there that led me to believe that one of these witnesses would have been able to support the essential elements of his case, even if they believed that he was being treated somewhat harshly by the new supervisor.
Commissioner David and then Commissioner Douglas.
Yeah, Bob, thank you for appearing personally. I know I'm not there, but it does add to the ability to hear the case. You just answered the question that I was going to ask you, and that is, how do you evaluate? You must be put in the position all the time of people saying, I want you to interview 32 different people. You do tell them that they have the right to introduce an affidavit or a letter, and you would then make a discretionary decision as to whether to go further in interviewing that witness. Is that right?
That's essentially it, that if there's something in the written statement that goes to the heart of one of the allegations in this case, I make it a point of telling parties that if they want to provide the statements, if I feel the urge or the need to follow up, I'll certainly go ahead and do so.
And he submitted no statements from any of those 17 witnesses that he said had vital input, right?
The written statements were submitted, again, generally supported his suggestion that this supervisor was, again, intent or maybe retaliating against him. But again, there was no tie to any prior act that would have caused the supervisor to want to retaliate. Again, in this case, the intent to take, let's say, paternity leave at the beginning, as noted in the report, that's not protected by the Maine Human Rights Act. So even if the supervisor is motivated to retaliate, the intent to take leave simply isn't covered by the laws that we enforce.
So to the extent that there were witness statements submitted, you evaluated them and took them into consideration in your total evaluation and conclusion?
I did. The entire file has been and was reviewed in detail before the report was prepared.
Thank you.
Yeah, my question.
Okay. Mr. Gordon, we're not hearing from the parties at this time. Any other commissioner questions for Bob? No, thank you. All right. We have heard from the parties and the investigator. This time we're looking for a motion. There are two proposed findings.
I'll move that we take them together and that we find that there are no reasonable grounds to believe that responded discriminated unlawfully on the basis of sex, familial status, or disability, and no reasonable grounds to find that there was unlawful retaliation. And the complaint should be dismissed.
Second.
Moved and seconded. Any discussion? Okay, seeing none, the motion is to find no reasonable grounds on both recommended findings. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
So the commission will send a letter to the parties confirming the results of the hearing. We want to thank everybody for their participation. Ed, I'm sorry to do this so early in the day, but could we take a 5-minute break?
Okay, we'll be in recess for 5 minutes.
May I ask, am I clear to leave at this point? Or do I need to?
Or if you, when your case is over, you're free to leave.
Thank you.
We all set?
All set.
Okay, the second case for hearing is E24-0159, Nicole Fifth versus Creative Works. The recommendation on both counts, accommodation and discharge, are for a finding of no reasonable grounds. Therefore, we will hear from complainant.
there's somebody here for Ms. Fritz. Seeing none. Julian, will you just check in the waiting room and make sure there's not somebody sitting outside by the lottery office?
Yeah, please do that.
No. Alex, you haven't heard anything from her.
Third case for hearing is,
Hang on a second, Dave. Ed, Jillian is just checking to make sure she's not out in the lottery office waiting.
okay,
Yeah, and then we do still have to vote on the report.
oh, I'm sorry, yes, we do, all right.
Okay. So it does not appear that complainant here. In cases like that where there is a no reasonable ground finding, we generally take the recommended findings of the investigator unless you have questions for them. They are here this morning if you have anything you'd like to ask. Okay, none. Thank you, Alex. Thank you, Attorney Finberg, for being here. So there are two proposed findings in this.
Move that we take them together and find that there's no reasonable grounds to believe that respondent discriminated unlawfully on the basis of disability, and no reason to believe that respondent discriminated unlawfully on the basis of disability, discharge, and therefore the complaint should be dismissed.
Second. Moved and seconded. Any discussion? Okay, seeing none, the motion is to find no reasonable grounds on both counts. If you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
Okay. All right. So the commission will send a letter confirming the results of the hearing to parties.
Third case is E240165 Kelly Welch versus Gnome Landscaping. The recommendation is for a finding of no reasonable grounds on the one count. Therefore, we'll hear presentation from complainant.
There's somebody here for Kelly Welch. That's you? Okay.
Yes.
You have, good morning. You have 10 minutes. Like I said to Mr. Gordon, that's your total time.
Right.
You'll present, the respondent will then present. If you would like to save any of those 10 minutes now to respond to what they say afterwards, you may just tell me how much you'd like.
If I can maybe some 6 minutes.
You want to use 6 minutes to start with?
I think I can read whatever I want
Okay.
in that entirety.
Okay. If you could just speak up a little bit so that folks on, so that Ed can hear you.
Okay.
Whenever you're ready.
I wanted to just read what I had written on the 17th of September 2024. And it was a reply to the Maine Human Rights Commission and myself versus Gnome Landscapes Design, Masonry, and Maintenance. Let it be known, I write the following with complete truth, reasoning, and self-integrity. I understand initially Gnome's harassment policy from employee handbook, but had reservations going forth with complaints for fear of jeopardizing employment, exclusion from peers, and additional harassment. After ending my employ, I realized that I needed to have my voice heard so that others would not have the same happen to them. I did contact bookkeeper, human resource manager regarding a separate incident at an orchard. I had injured my left knee slipping on ice, walking back to work site after the break. The HR manager contacted Memic, but the claim was denied due to no evidence on my part. And I continued with my own physical therapy and did not pursue. In Gnome's initial position statement, it reads that I told the Memic representative
that rather than appeal that denial, that I would instead file a complaint alleging Noam subjected me to sexual harassment by a supervisor. I did mention the harassment to her, and she asked for the names, but I told her I did not feel comfortable divulging any name, but yet she wrote in something else that I did give her his name, which was not true. At the time, I was still processing whether or not to pursue justice deserved or at least prevent others from being exposed to harassment in any manner, as stated earlier. And I believed, as a woman talking with another, my guard was easily down and apparently more comfortable sharing the fact that sexual harassment, among other types, did happen. And after much deliberation, I decided I wanted to share the distressing experience. The substance of the sexual harassment came in the form of masturbation, ejaculation, and groping, seemingly at the time antics, but as time passed, it really bothered me, knowing it was very wrong and that I felt more and more victimized. I was also called slow and retarded several times, but would try to brush it off. This constant abuse festered inside of me, leading to the morning of the 25th of March, 2024. After a sleepless night with failing parents and a leaky car tire discovered on my way to work, and I was about 15 minutes late, that I decided to cease employment. And all my life, I've had long-term jobs in good standing, and if having to leave would always give 2 weeks, if not more, notice. This aside, many employees there, the male majority, are harassive and abusive towards their coworkers, along with unending remarks regarding the female clerical employees. And I believe poor diet, nicotine, whatever other drugs and systems in sheer uncouthness contributed to the hostile encounters I saw more often than not. One incident in particular happened at the orchard. Two men, one was seemingly paranoid and whacked out on a drug of some sort, were in a seriously heated debate. It was very alarming to me that I had to tearfully walk away out of fear someone was going to be hurt. Two coworkers thankfully approached to ask if I was all right. I did appreciate their actions after the fact, especially since one was involved in the aforementioned heated debate. And these incidents are just a portion of my experience with Noam. I did thank the VP upon resigning for the opportunity of employment, as I did not want defamation of character bestowed upon me. Important to me also is I was a victim and strongly feel no blame to these situational burdens. And just thank you for time for reading. And then see real brief. And it had been with the main argument is that I feel I was discriminated against because I'm a woman, and the second argument was that investigator said that W was not a supervisor, yet it clearly shows from years before and this that the MEMIC representative on the statement of rejected claim referred to him as a supervisor, and Ms. T's statements dated July 24 in 2024, along with Ms. L's investigative report from April 26, referred to him as a supervisor. He drove the truck, interacted with clients, and told me what to do. It was just myself and him in work truck number 1. I feel liability is established based on the fact that it happened in and out of the Noam truck and Noam jobs. The discrimination occurred because I was a woman. Whether or not he was a supervisor, technically, in my mind, he was, because he told me the tasks at hand to complete. And also, Noam was supposed to train him, and the only evidence that they showed of signed off training dated to 2013. and this was in 2024.
Ms.
And-
Welch, I just wanted to let you know that timer was 6 minutes. I've
Oh,
continued with
okay.
the rest of your time, but
Okay.
if you would like to stop, you can. If you want to keep going, that's fine.
Okay, I'll keep going for another minute or so.
Okay.
Minute. I resigned for fear of retribution, and also in the investigator's report, violation on the basis of sex, maybe in a woman, did create an intimidating, hostile, and offensive working environment. And there are two things referred to from 1996, Nadu versus Rainbow Rugs. This happened in Maine. And the case established a standard requires an objectively hostile or abusive environment, one that a reasonable person would find hostile or abusive, as well as the victim's subjective perception that the environment is abusive. A reasonable person to me would conclude that masturbating in front of a female is abusive. Therefore, I disagree with the 10th of April 26 report under 5 analysis number 3. And also at one point in the truck, WM asked me, "Are we good?" And I could read or after. Let's see. And also, I feel my case is akin to 93 Harris versus Forklift Systems and 86 Meritor Savings Bank, and I have violating Title VII Civil Rights Act. Also, at one point in WM's statement, he's quoted as saying, "I never heard no," and it was something to that effect. So I'm probably up.
So the commissioners may have questions for you.
Okay.
Looks like, yes, they do. Okay, I'm just gonna go down the line. Commissioner Sanders?
Good morning. Thank you very much.
Yep, thank you for having me.
Of course, we really appreciate your time and thank you for pursuing this claim. It's important that we hear from you and certainly others
Yep, I'll do
who've
the second.
experienced harassment like you have in the workplace. Part of what we need to assess here today is whether or not your employer knew, right, that this was going on. And so the investigator's report reflects that the employer was not aware of the harassment that you alleged. And I wonder, I think I heard something in your comments just now that reflected, in fact, your employer was aware or should have been aware. And I just want to clarify that point. Are you alleging today that no either was aware or should have been aware while you were employed with the company?
It's hard to say. Well, I guess I am saying that they may have been aware, but through WM, sure, because I feel that he lied in his report. I left the job on the 25th of March, 2024, without going to HR because I was I don't know, I've never experienced anything like that. And and yeah, as I had read before, I guess I was just I was nervous about it, and we were welcome at the job too if there were personality conflicts, because there would usually be 2 people in a truck, and if there was an issue with that, you could change who you work with. But I kind of didn't feel confident or about saying anything because there's so many people there that all they did was, it was like this hen fest of talking about all these coworkers, all the, it's just, so I just felt like I was going to, just have more, and, I had a lot going on and I had moved a few times and,
So I think what I hear you saying is that understandably, it was difficult, right, to speak up and report it. But I think what I hear you saying is that prior to the time that you resigned on March 25th of 2024, that for all the reasons that you described, you had not in fact reported the concerns that you had about sexual harassment. Is that correct?
I suppose it is. One time I did, to the VP, it isn't the sexual harassment, it was just there were a lot of scary incidents and like the orchard and the fight and,
But with respect to the sexual harassment, you had not reported.
I didn't while I was employed. No, I did, I can't, a week or two after.
Yeah, and I see that in the investigators report. The other question I have, and then I'll hand off my time to my colleague here, relates to something you wrote in your objection to the report. You indicated that that the employer had not in fact trained employees, at least on an annual basis, about the prohibitions against sexual harassment. And I wanted to give you an opportunity to tell us more about why do you believe that's true, right? That no, did not in fact train employees as they should have.
Yeah, I didn't mean for it to come across as they did not. They did. I was a part of that, and we'd all be in one room. And I guess my point with that is that with their lawyer, they had their evidence as the last reported sign off of 2013. And I thought, it should be at least from 2023, or whether it was lost in HR or what. That was the point of that.
Okay.
Does that make sense?
Yes, it does. Thank you. Okay. Commissioner O'Brien.
Thank you. First of all, it's not easy doing what you just did. And thank you. Thank you for, you did a good job, did a great job. And Commissioner Sanders asked some of the questions I was going to, but we have to make a connection between did they know, didn't they know, and all that. It's not that we don't believe you. I totally believe everything you said, and I'm really sorry you had to go through that. So depending on, we'll see how this goes, but it's not that we don't believe you.
Yeah, well, thank you, because it's my honest,
I believe you. Yeah. Okay, that's all.
Okay.
Yeah.
Commissioner Douglas, sorry, Commissioner Walker, did you have?
No question.
Okay, Commissioner Douglas.
All my questions have been addressed at this point. I would just echo my commissioners and say, I appreciate you coming in. It's brave what you're doing today. And
thank you.
I don't think anybody on this bench doesn't believe that this may have happened. And certainly nobody believes that it's not absolutely awful if it did happen.
Yeah.
I want you to understand that.
Oh, thank you. And I'm sorry to be so blunt with the wording and all, but I just, it took me a lot, yeah, so that's all.
Yeah.
Commissioner David?
Yes, Ms. Welch, as I understand that some of the most horrendous incidents were with the supervisor. Is that correct?
Yes, and my understanding is he was a supervisor, but then there was an argument brought up that he wasn't, and that he was merely a liaison to the properties that we would work at.
All right, they'll make that argument, I'm sure. My question to you is, when you did make the report, to your knowledge, was that individual disciplined in any way?
I don't know.
Was
there
he still working there?
I believe so, yes. And
Okay,
I believe that I understood that I wasn't going to contact them, and nor were they going to contact me. After I gave the report to the human rights.
were you still working there?
No, I did this after, I think it
I
was
see,
with,
okay, yeah.
yeah.
Thank you.
Thanks.
Any other commissioner questions at this point? Okay, you have about 1 minute and 46 seconds when we come back to you. So you can sit and we'll hear from the respondent and then we'll call you back.
Okay, thank you.
Thank you. Attorney Monroe, you have 10 minutes. Do you want to reserve any of that time?
Yes, let's please reserve 3 minutes.
Okay, whenever you're ready.
Thank you. And good morning to the commissioners. Good morning to everyone. Ms. Welch, I appreciate you being there to give your perspective on this. So from the respondent's perspective, the allegations did not come up, as Ms. Welch made clear, until after she had departed. And so during her employment, respondent had no reason to believe that there was anything going on, anything that would violate its policies. There were many opportunities for disclosure to happen during employment, and there were, for instance, the human resources manager was available. There would have been ways for her to the complainant to be separated from WM. Had she wanted so, she could have said so and not given even a reason, in that the management did, as complainant said, if there was ever a personality conflict, they invited people to mention that and to separate them so that they could work with a different team member. And in this situation, WM, his title was supervisor, but he was not complainant supervisor. He did not have the authority to hire, fire, or discipline anyone. He didn't have any control over their pay, over their terms and conditions. And he really acted as just the person or the go-between between what the homeowners were expecting and then the team getting that accomplished. So while he was titled a supervisor, he was not a supervisor. And I understand the situation where when someone comes forward, like the complainant did, the impulse to believe and embrace the allegations. I've spoken with WM. WM cooperated with the investigation, with the investigator, and credibly denied the allegations. And there have been no other allegations against him. He has worked with other women, other men, other people throughout his time. He's a long time, very good employee, and has never had any kind of allegations like this before or since the complainant came forward with her allegations. So we were unable to find any corroboration to her allegations. So the circumstances of disclosure, the allegations, the credible denial. I understand why the investigative report came forward with the no reasonable grounds recommendation. The only piece to the investigator's report that we took issue with is whether or not WM was a supervisor under the applicable law. So our position is that he was not. But again, regardless, this is a respondent that had appropriate policies, trained people, kept people apprised of its expectations, and had no idea that these allegations would even exist until well after complainant voluntarily resigned on a day that she came to work late. So we're in a position where we've not found any corroborating evidence. I would ask the commission to find no reasonable grounds in concurrence with the investigator's report, the primary findings on that.
Commissioner Sanders?
Good morning, Attorney Monroe. One moment, please, while I find the spot in the investigator's report. I want to clarify something, a remark that you made in your presentation just now, just to make sure I understand the respondent's position. I think what I heard you say was that even though the employer, the respondent in this case, called the individual who allegedly engaged in the sexual harassment a supervisor, right? They called him that. In fact, he was not a supervisor. So help me understand that disparity. If the employer was calling this individual a supervisor, why shouldn't we credit that and in fact conclude that he was?
So as you can imagine, respondent as a company trying to do their best, uses different titles to reward longevity and reward good decision making. And so when they are trying to convey to homeowners, customers, who their best point person is, then that person in this situation had a supervisor title. But it's not like respondent had gone back to the applicable laws for this to see, oh, well, does that person actually fire, discipline anyone? Does that person have any control over the terms and conditions? Does that person affect their teammates' compensation? And so the title they were using, and as to my knowledge, still probably used for WM over all these years, is that he's acting as a foreman or a team leader, but he is a supervisor is the title they've used. Now, again, legal standards there are different considerations for who is a supervisor than just what companies choose to call their employees.
Doesn't that mean though, and I'm going to press you a little bit on that, Attorney Monroe, doesn't it mean then that your client is trying to have it both ways, right? To communicate to the community and give the appearance, right, that there's a supervisor overseeing the work, but then, making the argument alternatively in the legal context that no, in fact, that individual is not a supervisor. And so doesn't that lend to a credibility assessment with your client that the commissioners need to make?
Well, in terms of a credibility assessment, I would hope that the commissioners would understand that most companies wouldn't necessarily go to the same definitions that we use when they're making up their titles over the years. But complainant knew that he didn't have any particular say over hiring or firing or discipline. I believe knew that he didn't change her pay or change her terms and conditions, and that she knew which people in management that she could go to say, I've got a personality conflict. I'd like to be assigned to a different person, paired up with someone else, or that if she wanted to make a disclosure or report of harassment, that she could have done so. The main reason this would matter is about the type of notice that respondent was put on. But our position overall is that there was no harassment. At least we found no corroboration of it. So whether WM was a supervisor or whether he was not, either way, respondent was not on any notice of any harassment, and still to this day has reason to question whether it actually occurred. So, I mean, again, I appreciate your concern that would the respondent be having a cake and eating it too? Are they holding WM out as a supervisor to customers? when they're, I mean, should they have been using the name liaison or team lead or foreman? I mean, I certainly understand that, and I can take that back to my client for consideration, but just the title in and of itself does not make him a supervisor under the applicable law.
Other Commissioner.
Just, is it, I think it's common sense, but in looking at the timelines, there's a gap in the winter time. Does that mean that they did not work in the winter?
Oh, there was snow removal so the respondent does have work for folks to do throughout the year. And there were different points in time, I believe, where complainant and WM might not have been paired together, and then times when they were. But again, respondent didn't know that there was any issue between the two of them. So I don't remember the exact timeline at this moment to know whether they worked together all winter long before March of 2024. I'd have to look back more on that, but they were teamed up together for different types of things seasonally. So.
Okay, thank you.
Commissioner David?
Attorney Monroe, as I hear you, you're saying that whether or not he was a supervisor, you investigated and he said it didn't happen, so you've closed the book. I mean, doesn't that leave us with a conflicting testimony and a credibility issue that a jury could make or a fact finder could make, and that's as likely as not that she might prevail?
Well, I mean, it's not that I've closed the book. The book is not mine to close or open or whatnot.
Well, the company didn't do anything. Is that correct?
Yes, that is correct. WM has not been disciplined because there's not been corroboration. We've not found any evidence that helps support complainant's position that she was harassed.
Would it be the company? Would it be the company's policy to record and document that complaint in his personnel file?
Well, the complaint has been documented. It ordinarily wouldn't be stored in his personnel file, but the complaint didn't come to us initially until well after her employment. And then she was even a little bit slow to disclose details or who it was and all of that. So that's part
of the trauma.
Well, it may be. But usually, and I say this as someone who used to prosecute sex crimes, used to prosecute crimes against children,
Right.
but typically there is some kind of corroborative evidence, whether it's someone else who can come forward, some kind of inappropriate text message, just anything else that comes from that time period that could lend some credibility to complainant. And again, I sit here, I represent respondent. I'm an advocate for respondent. And it's not my job to believe or disbelieve, but we weren't able to find corroboration that would justify disciplining WM. And that, I mean, so again, the commission's responsibility is a little different than mine here, but I would encourage you all to take faith that the investigator's report fairly covers things. The only issue that I dispute with that is the supervisor one, but that doesn't get you here nor there on the reasonable grounds issue. So
Right. Thank you.
Any other commissioner questions for Attorney Monroe? We'll have about 6 minutes left when we come back to you. Ms. Welch, if there's anything else you'd like to add, you have 1 minute and 46 seconds. You don't need to use it, but you may.
I do want to say that this harassment did happen many times. And in my original report here, which is state that I gave specific details where. One place was in Cape Elizabeth, one was in Cumberland Forside, and one was in Falmouth. And in the truck a few times. And it started in, it was in 24. Let's see. Yeah, my initial one was, it was 4 different work locations starting on or around the 28th of July, 2023. And I have the addresses, and most of these homes are very upper end, you know, homes, and have cameras, and I suppose that's all I have to say on that. I did my first year there. I started in February, and I was going to be on the Mo crew, as I had about 30 years experience at a golf course, doing all aspects. But in the end, the last 12 or 15, I worked maintenance, mowing, and all that. So I thought, oh,
That was
mowing.
their time.
Oh, okay.
Commissioner, yes, Commissioner O'Brien.
These, you said more instances now. Were other people ever around when this happened, or was it just you and him?
Mostly just me and him, but there were the property at Cape Elizabeth. They had the owner was from New York City, so they weren't there, but only a handful of times over the course. And but the property, the caretaker, she took care of painting, like yeah, just setting things up for, say, a painter or doing fixes. So she was there, and we would talk with her at times and all. And so, and then the owners there was a property next door, but the sexual part didn't happen there, but it was the property owner's sister and husband's home, and we would be there, but WM had good rapport with him, and
Okay, so there's no, so as far as you know, there was nobody that the investigator could have. So basically, this is he said, she said.
right, and I wrote that at some point in time. Yeah. Yeah.
Thank you.
Bye.
Any other commissioner questions? Ms. Welch?
Yes.
Commissioner David?
Just to follow up on that, Ms. Welch, you didn't produce any evidence from anybody else that you had told contemporaneously about what was going on? Any friends, or you didn't bring any evidence in with affidavits or statements of other people? Or were there no one that you disclosed it to?
Yes, I did, to one friend.
Did you produce that friend in the case? Did you get an affidavit or ask the investigator to interview her?
No, I didn't do that.
Okay.
But he's present.
She what?
The record is closed at this point.
Yeah.
We can't hear from anybody right now.
Yes.
Any other commissioner questions for Ms. Welch? Hearing none, thank you very much.
All right, thank you.
Attorney Monroe, you have 6 minutes and 9 seconds.
I have nothing else to add unless there are any other questions.
Or any other questions for Attorney Monroe? Being none, We have heard from the parties, and next we'll hear from Nupur Leva, the investigator assigned to this case.
Good morning, commissioners. So everything is laid out in my report, but I'm anticipating some questions. So I'm going to go ahead and let you guys ask questions.
Good morning. Thank you very much. I'm looking at page 4, numbered paragraph 5 in your report, Investigator Leva. If you go second full sentence, reads, when the supervisor's harassment results in a tangible adverse employment action, liability attaches to the employer regardless of whether the employer knew or should have known of the harassment, and regardless of whether the specific acts complained of were authorized or even forbidden by the employer. Can you walk us through how you drew the conclusion that there was no tangible adverse employment action in this case?
Sure, absolutely. So to me, a tangible adverse action would be something like she was fired or disciplined or something of that nature. And that in this case, none of that happened, and she resigned of her own volition. So I drew that there was no tangible adverse action.
Curious. Thank you for that. I'm curious, had the complainant made an allegation of constructive discharge? Could that allegation have served as an allegation? Could we have concluded on that basis that there was a tangible adverse employment action?
Possibly, but again, that was not a claim that was ever alleged, so that was not something that I ever looked into.
Thank you.
Any other commissioner questions for the investigator? Commissioner O'Brien?
Thank you. In your mind, is there an issue of credibility?
So sorry, go ahead.
No, go ahead.
I was just saying, so for me, the credibility issue here wasn't as much of an issue as to whether or not respondent knew, and then whether or not the way the liability attaches according to our law was actually established. With all of the facts that I had in this case, liability didn't actually attach to hold respondent liable.
Any other commissioner questions for the investigator? Commissioner Davis?
Nupur, was there any indication from the complainant of any other contemporary disclosure to a friend or witness, or did you ask her that? Or did she say that other people knew about it?
So this case was given to me after most of the investigation was done. I had it towards the very end, and I did some final investigating and final information gathering, but there wasn't anything that I got that would give me any notion that any form of liability would attach to the respondent, or that there was somebody else who had contemporaneous knowledge that the respondent knew of.
And that's from your review, because you didn't do the case from the beginning, is that right?
Yes.
Oh, okay. Thank you.
Mm-hmm.
Any other questions for the investigator? Seeing none, thank you, Nupur. Heard from the parties and the investigator. At this time, you're looking for a motion. There is one proposed finding.
I'll move that we adopt the investigator's recommended finding and hold that there are no reasonable grounds to believe that the respondent discriminated against Ms. Welch on the basis of her sex, and the complaint should be dismissed in accordance with 5 MRS 4612, subsection 2. Second.
Moved and seconded. Any discussion?
Yeah, so obviously, I mean, allegations in this case are very, very troubling. And as I said to you earlier, Ms. Welch, I don't want you to leave here thinking that anybody didn't take them seriously, or, we don't know what happened. We weren't there. There's no reason for us to believe these things did not happen. The reason why we're making this motion, the reason why the investigator found the way she did is really because you quit first, and then you reported the action. And that's something you couldn't have possibly known. And the reasons why you did that, and the reasons why you didn't report the action are perfectly reasonable to me. I think they're reasonable to everybody up here. So I understand that. Fortunately, you weren't aware of the technicalities of the law, I think, when you did that. And so I just wanted to say that to you and to say, we appreciate you coming here today and your statements and your bravery in presenting this to us. So thank you.
Any further discussion?
I agree with everything that Commissioner Douglas said, and yet I'm gonna vote against it. There needs to be a way to find justice here. There needs to be a way to air that credibility conflict. I find her presentation credible. I think that she constructively was discharged, and yeah, obviously she didn't have the wherewithal to do that properly. But I understand.
I agree with you, Ed.
Barbara, I've got a question for you. To the extent that the complainant did not allege constructive discharge in the matter, right, leading up to the investigator's report being issued, and did not allege it in her statement of disagreement, is that something that the commission is able to consider at this stage, to the extent that she made that argument perhaps today?
Well, hang on. Been thinking about this as this argument occurred, so let me just gather. So constructive discharge is not a standalone claim. So the way we look at supervisor liability for harassment, there are two ways to find liability. The first being that there was a tangible adverse action, and constructive discharge can be a tangible adverse action. I would say you can find whatever you want. So if what you've heard convinces you that she is at least as likely as not to succeed on her claim, considering what you've heard, then you would vote in that manner. I mean, the other way is knew or should have known and unreasonably failed to take advantage. But I don't think that's what you're talking about here. To the extent you've heard enough to convince you that a constructive discharge would be a viable claim, then I think you can consider it.
Thank you. Curious, Commissioner Douglas, if that might sway your thinking in this matter.
Appreciate being called out by name. Thank you.
So I will answer.
45 seconds.
I will answer since I seconded it, and the answer is no. It doesn't. Constructive discharge, I would be bothered by the same thing, that there wasn't enough information to the employer to constructively discharge that employee.
Well, constructive discharge is when the individual
Makes the
decides
decision to leave.
because no reasonable person could
Yeah.
put up with the environment. So just to the extent you're looking at what information the employer has, I just wanted to make sure you're focused on the right thing.
Yeah.
And in that case, right, liability attaches, if we believe this individual is a supervisor and we believe that there was tangible employment action, the law doesn't require, correct me if I'm wrong, Barbara, the law does not require that the employer had to have known or should have known.
Correct. It's direct liability if there's a tangible employment action.
Okay. I did not know that. I stand correct.
I just keep going back to at least an even chance. You all have said that all, I've never used that. You said it, and now it's my turn.
Any further discussion? So the motion on the table right now is to find no reasonable grounds on the one recommended finding. If you vote yes, you are in agreement with that. Commissioner David,
No.
Commissioner O'Brien,
No.
Commissioner Douglas.
Okay, you skip me.
I can go to Commissioner Walker since you came on at the same time. Commissioner Walker,
Yes.
Commissioner Douglas. Commissioner Sanders.
No.
Okay, so the motion fails, which I believe means we need a new motion. Somebody like to make a new motion? Commissioner O'Brien.
I move there are reasonable grounds to believe that Gnome Landscaping discriminated against Kelly Welch on the basis of her sex and the complaint. Oh, not sure.
Period.
Should be conciliated.
Yeah, should be conciliated.
Yeah.
Second.
Okay. Any further discussion?
Yes.
Great.
So here's what I'm troubled by. I think Barbara answered it, but I'm gonna raise it again. So we have a supervisor, right? In name, actually, whatever it is, allegedly committing these acts, which are awful, right? And we have an employer that's named in this proceeding, right? The supervisor, liability could attach to the employer based on the supervisor's conduct under certain situations.
Okay.
What I thought I heard Barbara say is that in this situation, the fact that, I mean, I'm just thinking through my knowledge of respondent superior, and you know what I mean? Like, it seems problematic to me that this is sexual harassment, number one, right? And number two, I mean, these are intentional acts, right? And number two, the employer did not know. So I don't think it's as cut and dry as, you know what I mean? But if anybody wants to provide some more feedback.
Yeah. The way I'm thinking about it is that if we credit to two things here. One, if we believe there's enough question about this individual's status as a supervisor or not as a supervisor, right? So that's the first question. If we credit that there's at least an even chance to, again, assume he's a supervisor, that's thing one. And then thing two is if we credit complainant's allegation that her resignation is a constructive discharge and therefore an adverse employment action, tangible adverse employment action, those two things could establish liability regardless of whether the employer knew or should know.
Yeah, I mean, I've probably had too many of these cases where we've got an individual that acts intentionally and we've got an institution that employs that individual. Do you know what I mean? And that we're trying to hold the institution liable. It's just
as a supervisor.
Typical. Well, I understand, but I don't know. Anyway.
I'm gonna read you what we give the investigators for constructive discharge boilerplate, just in case it helps. An employee may use the doctrine of constructive discharge to satisfy the elements of discharge or adverse employment action. In an otherwise actionable claim, an employee is constructively discharged when they have no reasonable alternative to resignation because of intolerable working conditions caused by unlawful discrimination.
It is what it is. I just vote.
Any further discussion? Okay. Seeing none, the motion is to find reasonable grounds. If you vote yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
No.
Commissioner Douglas?
It pains me, but I'm still voting.
Commissioner Sanders?
Yes.
Okay, so. Okay, so the motion, sorry, my brain has just rebooted. The vote is to find reasonable grounds. So the case will go to conciliation. The commission will send a letter to the parties confirming the results and instructing you what the next steps will be. We'll get that this week by email, right, Jane? Okay. We thank you both for your participation, and we will move on to the next case.
Fourth case is Florence Bajanen versus St. Mary's Medical Center, E240167. The recommendation is for findings of no reasonable grounds on 3 counts, and therefore we would hear first in presentation from complainant.
Good morning, commissioners. Thank you all for your time today. My name is Attorney Meredith Scott, and I represent the complainant in this matter, Florence Bajanen. This case concerns an employee.
Attorney Scott.
I need to recuse myself.
Okay. Last minute recusal, and I also, do we have somebody? That's right. Do we have somebody here for the respondent, just so we can pin you?
Yes, Elena Gilligan here for Respondent St. Mary's.
Okay, thank you, Elena. Attorney Scott, do you want to reserve any of your time?
Yes, I would like to reserve 2 minutes. Thank you.
Whenever you're ready, go ahead.
This case concerns an employee with an excellent performance record who suffered a severe injury, informed her employer about that injury and her expected recovery, and then was approved for FMLA leave. Less than 2 weeks after her surgery, St. Mary's then terminated her employment without offering her an alternative position, despite the fact that the respiratory department she had successfully led since the beginning of COVID remained understaffed and had open positions at the time that it was actively trying to fill, both before and after her termination, and that they replaced her with an individual who was not experienced in supervising the respiratory department and was able-bodied, unlike Ms. Bajanen at the time. The evidence before the commission is sufficient to establish reasonable grounds to find that St. Mary's discriminated against Ms. Bajanen because of her disability, age, and retaliation against her for exercising her right to both protected medical leave and her anticipated reasonable accommodation request when she would return to work. So Ms. Bajanen has a qualifying disability under the Maine Human Rights Act. After being struck by a plow truck, she suffered a shattered ankle, heel, multiple fractures, a concussion, as well as a crush injury. Surgery was then delayed because of the severity of her injury, and she was expected to remain non-weight bearing for months afterward, according to her medical providers. And ultimately, she did not return to work for over 6 months. And even when she did in June of 2024, she still required accommodations at that point in time. And St. Mary's knew the nature of her injuries throughout her recovery timeline, as was told to her by her providers, and that she would require significant time away from work before returning. The timing of the termination in this case strongly supports a finding of discrimination. She was injured on October 31st of 2023. She underwent surgery on November 27th and was terminated on December 11th, less than 2 weeks later while on medical leave. And the termination came immediately after St. Mary's learned the estimated duration of her recovery and that she would not be able to return to work in the near future. St. Mary's asserts that the termination was part of a reduction in force, or RIF, but under the burden shifting framework, the evidence goes against St. Mary's asserted reasons for the termination and demonstrates that the reasons are pretextual and that her disability status and her protected leave were motivating factors in her termination. At the time she was terminated, there were 2 respiratory therapist positions that were vacant in her department as they were short-staffed. Both carried $15,000 signing bonuses. As St. Mary's acknowledged in its own answer in this case, the hospital was actively trying to fill those respiratory therapist positions and was not eliminating any direct care roles as part of the reduction in force. So if cost savings and staffing reductions, as St. Mary's asserts, were the real reasons behind these decisions, It's difficult to reconcile that explanation with the efforts to recruit respiratory therapists with significant financial incentives, those signing bonuses when the department was understaffed, could have saved money by retaining an employee who was qualified, had over 20 years of experience, was licensed for those positions, wouldn't get that bonus, and was clearly familiar with the department and was used to providing direct care as a significant part of her role as director. But she was never offered either open position. And the events following her termination also pose additional concerns about the reliability of St. Mary's account of the events. While Ms. Pajanin was recovering, St. Mary's reported incorrect insurance termination date, which resulted in the initial denial of her medical claims incurred at the time. There are delays in providing her COBRA paperwork necessary to continue her medical coverage. And she was terminated just 20 days before becoming eligible for the employer match to her 403B account, which would have vested on December 31st, and she had completed about 98% of that period. St. Mary's primary explanation for not offering one of the vacant respiratory therapist positions to Ms. Pajanin is that she allegedly behaved unprofessionally during the termination call. However, St. Mary's has not produced a recording of the call. There's been no transcript, no other contemporaneous documentation or notes about that phone call or what was said. And they are now asserting that this call was the reason for their refusal to offer her an alternative position. By contrast, if you look at the record, there's years of performance evaluations for Ms. Pajanin, describing her as professional, calm under pressure, an excellent communicator, and she was regarded as one of the hospital's most respected employees. We also asked that the commission consider the respondent's limited cooperation during parts of the investigation, such as refusing to identify all of the decision makers involved in the reduction in force decision, or to provide affidavits explaining their roles and rationale. The respondent also did not provide information including other employees affected by layoffs and employees who had taken disability-related leave. The evidence that has been produced in the record is more consistent with Ms. Pajanin's account than with St. Mary's effort to portray her as unprofessional during that call. Furthermore, St. Mary's account of the phone call just doesn't logically add up. It entered the call, according to St. Mary's, intending to offer Ms. Pajanin the alternative respiratory therapist position, but changed course supposedly during the call because of her reaction to being told she was losing her job at a time where she was experiencing a traumatic medical incident, an explanation that directly conflicts with Ms. Pajanin's account, who recalls being sad, of course, rightfully, and shocked about her termination, but denies ever raising her voice or acting unprofessionally. And if St. Mary's had really intended to offer her that other position, why wasn't that discussed at that same time, rather than informing an employee, again, recovering from a traumatic injury, that she was being terminated, and then deciding afterwards whether to let her know that there was an alternative position that was available. St. Mary's internal communications also support this position. Prior to that phone call, an HR rep wrote to her supervisor providing information about her termination call with the comment offer position of respiratory therapist. However, after that phone call occurred at around 8 a.m. on December 11th, her supervisor wrote in an email, "I'm embarrassed that I missed that we actually had the option to offer Ms. Pajanin a position as a respiratory therapist." So this statement is inconsistent with what St. Mary's has asserted and suggests that the position was not intentionally withheld because of what she said during that phone call with that same supervisor. So it doesn't make sense. Why would the same supervisor from that call still be discussing?
That's 8 minutes. Do you want to continue?
Yes, I'm almost done. Thank you. And this appears a lot more likely than the after the fact explanation constructed by St. Mary's. And finally, her disability does not need to be the sole reason for St. Mary's decision. The question is whether her disability and her status on protected leave were motivating factors in the decision to eliminate her position and not to place her into one of those available alternative roles. And for those reasons, we respectfully ask the Commission to find reasonable grounds on both the disability discrimination and the retaliation claims in this case. Thank you.
Commissioner, questions for Attorney Scott? Commissioner David?
Attorney Scott, I don't hear you making any argument on the basis of age discrimination.
Based on the record, I think we and my client decided to focus more on the discrimination and retaliation claims. Again, those are the parts most strongly supported by the record, and there's substantial evidence concerning St. Mary's knowledge of her injuries, leave status, and the decision to not place her into those positions, like I said. And the evidence concerning age is a little bit less developed, so we're, again, just concentrating on the claims that are clearly supported by the record.
And you say, back to the phone call, that you say that it's, I don't know, it seems to me that you say that it's obviously pretext to say that they didn't offer her the other position because of her reaction and unprofessional behavior. It seems to me that that's totally credible. Can you react?
Sure, yeah. So that email afterwards, again, I mean, in St. Mary's answer, they assert that they decided during that phone call, based on her reaction, not to then offer her the respiratory therapist position, which, again, going into the phone call and not bringing it up at all doesn't really add up. But at the same time, then that same supervisor who was on the phone call and who allegedly, as he said, was not going to offer her that role because of her, attitude or confrontation during that point. He wrote afterwards, I might have missed offering her the position, which again goes against what St. Mary's asserted in its own answer, saying that it did make that decision purely based on, her reaction during that phone call at that time.
And my last question is, at the beginning of your presentation, I thought I heard you say that your view is that the reduction in force was a pretext. Why do you assert that was a pretext?
I don't think the entirety of the reduction in force that was going on with St. Mary's was pretext. I think Ms. Pajanin doesn't dispute that St. Mary's was conducting, a broader reduction in force. Yeah. But the question really in our minds is whether her disability and medical leave played a role in how she was treated during that process, particularly with why she was not offered one of those positions while outside candidates were being recruited with $15,000 signing bonuses for those alternative roles at that point in time that she was qualified, licensed for, would have been, and also provided direct care pretty consistently as part of her role as director. And really the question is, why was she then not offered an alternative position at that point in time?
And why is that? Why doesn't that tend to suggest that it's precisely because of her behavior? As you argue, they could have saved money. They could have offered that if it was a mistake not to have done it in the phone call. They could have come back and corrected that within a day or two. But she blew it. And that's their position, right?
Mm-hmm.
Okay.
Right. And they didn't want to wait for her to, spend 6 months recovering from a surgery before her coming back to fill in that respiratory therapist role.
So it would have been another 6 months
likely,
at that time?
Right. I mean, she had an estimated time frame of about 3 to 4 months plus some rehabilitation and physical therapy following that.
Okay. Thank you.
Commissioner O'Brien?
Thank you. I'm just curious, and I apologize if it's in here, but was she aware in October that it says here that the president notified the HR manager that the respondent was planning RIF. Was she aware of this?
Of the RIF happening, the reduction in force generally?
Yes.
Yes,
Yes.
she, as the director of her department, had spoken to several of the staff that were hired from that external group to kind of, conduct the labor analytics about which roles should be eliminated or not. She had worked with them. They had given her very positive feedback about how she had reduced costs in her department, and they talked at length about the fact that her department was still significantly short-staffed. And they had a pretty urgent need for respiratory therapists at that time.
Thank you.
Any other commissioner questions for Attorney Scott? Okay. Seeing none, you'll have 1 minute and 20 seconds when we come back. Attorney Gilligan, you have 10 minutes. Do you want to reserve any of that time?
I will reserve whatever time I have remaining.
Okay, whenever you're ready.
Likely about 6 minutes or so, probably. Thank you. Good morning, commissioners, and thank you for the time this morning. My name is Elena Gilligan, and I represent respondent St. Mary's Regional Medical Center. This case arises from a difficult but lawful business decision, a hospital-wide reduction in force, undertaken during a period of significant financial distress. The evidence supports Investigator Brindley's report and clearly shows that complainant's position was eliminated as part of a data-driven restructuring. The decision was based on operational efficiency and cost considerations, and it was entirely unrelated to age, disability, or protected leave. Accordingly, the complaint lacks factual and legal support, and St. Mary's respectfully requests that the Commission accept the investigator's recommendation and find that there are no reasonable grounds to believe that St. Mary's discriminated against complainant on the basis of age or disability, nor retaliated against complainant for engaging in protected activity, and dismiss her complaint. By way of background, St. Mary's had been experiencing financial difficulties, and in the summer of 2023 undertook planning for a reduction in force. St. Mary's partnered with third-party tools and consultants to identify cost savings and staffing reduction opportunities. These tools analyze staffing levels, productivity, and cost efficiency. Complainant's department, the Respiratory Services Department, was identified as exceeding optimal staffing and needed to be reduced by 1.34 FTEs. The organization then made targeted staffing decisions consistent with those findings, and critically, direct care staff were needed and retained, and administrative overlap was reduced. And that is precisely what occurred here. The decision to eliminate complainant's position was based on operational realities. Her responsibilities could be absorbed by a director of a larger department, Rehab and Work Med, and that director had overseen portions of complainant's department in the past, had worked at St. Mary's for 20 years longer than complainant, and complainant managed a relatively small department, and she did not have the experience to oversee the larger Rehab and Work Med department. By contrast, the other employees in the Respiratory Services Department were direct care respiratory therapists, and St. Mary's was looking to fill open respiratory therapist positions in the fall of 2023, so eliminating direct care staff would have undermined patient care needs. This was a structural consolidation decision. In early October 2023, before Ms. Paginan's accident, the hospital's president notified HR of the planned reduction in force and that it would result in the elimination of 129 positions, including 31 layoffs. Complainant's position was ultimately one of the positions eliminated. In December of 2023, St. Mary's carried out that reduction in force. On December 11th, complainant's supervisor and HR business partner called complainant to inform her that her position was being eliminated. They also had planned to offer her one of the respiratory therapist positions, but during the call, complainant became unprofessional and yelling and making threats towards St. Mary's. As a result, complainant's supervisor forgot to extend the offer to complainant for the respiratory therapist position, and then after considering her conduct during the call, St. Mary's ultimately decided against offering complainant the direct care respiratory therapist position. I just want to make it clear that it was never St. Mary's position that this decision was made during that call. But Ms. Paginan's age or disability or any protected conduct was not a consideration in the inclusion of her position in the reduction in force. I'm happy to answer any questions.
Dr. Sanders?
Sure. Good morning. Thank you for being here. This whole notion, right, this whole sort of sequencing with the phone call, allegedly complainant was unprofessional during that phone call. And then so at some point thereafter, right after the phone call, supervisor sends that email to the HR rep to say, I missed making the offer, go ahead and let's offer it. I'm kidding. So that's a curious fact to me, right? If your position is that she objectively, right, behaved so unprofessionally during that phone call that, you know, no offer should have been extended, why would her supervisor have followed up and said, go ahead and offer her the position? Doesn't that materially weaken your client's position?
No, I don't think so. The supervisor had a list of folks he was talking to that day. He made an error, and the email sent to the HR partner was, if you find it appropriate, and the HR partner in consultation with the rest of the HR department talking about the conduct, Ms. Paginan's conduct during that call, ultimately decided it was not in their interest to move forward with offering her that direct care respiratory therapist position.
But the supervisor doesn't evidence any indication in that email, right? Supervisor doesn't say, I'm alarmed by the conduct. That's not what St. Mary's expects of, right, employees who are going to be working for the organization. You know, my thoughts are we don't offer her that position, right? None of that was communicated. So there's a fair inference, isn't there, that the supervisor didn't necessarily think that the complainant's conduct was so egregious during that phone call, it wouldn't have extended her an offer of employment. Isn't that right?
No, I can't speak to that. I'm the ultimate decision makers for this were the HR department and that HR business partner that was on the line with her and had that follow-up conversation with her.
We don't actually get a description in the investigator's report about what exactly happened during that phone call. I see here that there's some characterizations of what happened, right? There was yelling, there were threats made. Give us more detail. What exactly happened? What exactly did the complainant say?
I don't have her exact words for you. I'm sorry on that. I know that, and you know, I don't want to speak for Investigator Brindley, but I believe this was contemplated and admitted to by complainant, and that to the extent that she was emotionally distraught, but she escalated escalated very quickly, and attempts to de-escalate the conversation were failed, and she lodged a number of threats towards St. Mary's, and had made a reference to obtaining counsel. So at that point,
I don't know what those threats were, and you know, the fact that she indicated she was going to retain counsel, isn't that, I mean, that's pretty normal, isn't it? And I guess, so that's just an observation. And then separately, you know, couldn't your client have assumed in a phone call like this, understanding that the complainant had just sustained pretty serious injuries right outside of the workplace, knew she was going to need a leave of absence, was working through pretty serious medical issues, right? Would have understood that immediately. I need health insurance, right? If my employment is terminated, my health benefits terminate as well, and that's bad, right? That's bad for me. Couldn't you have, assumed or predicted that the complainant would have become very upset and emotional during a phone call like that? So I need to understand what exactly happened
I was not present for that conversation, so I
need everybody to stop interrupting each other.
Oh, I'm sorry. I did not.
Yeah, so I'm just curious, it would be really helpful, and perhaps complainants counsel knows, or we can certainly ask the investigator as well, but it would be really helpful to know with some granularity, what exactly during that phone call was so unprofessional, right, that they made the decision to not extend the offer.
Yeah, so again, I apologize. I was not part of that conversation, so I cannot give you direct quotes. I don't have direct quotes from my client. And what I can say is St. Mary's was in need of respiratory therapists at this time. They needed direct care respiratory therapists. And complainant's counsel is correct in that she was qualified for this position, and she was, by all accounts, a good employee. So the conduct that had to have occurred during this call must have been so egregious for them not to move forward with that when they had a very specific, very direct need. But to the extent, the specifics of what was said, I do not have that. I know she was making threats. And I know that she was yelling, and I know that she yelling at her supervisor and the HR business partner.
Thank you, Commissioner O'Brien.
Thank you. Complainants counsel made a point of saying that we have no recording and we have no transcript of that call. Do you know if one exists, and were you asked for that?
There is not one that exists. And we were not asked for it. This was a trying time for respondent as well. Like they, were in a tough position to have to lay off folks and this large restructuring. And I know that they were working through all of the lists that day. So there was no recordings of the individual conversations.
Okay, thank you.
Commissioner David?
What was to be her last day of work?
December 11th.
And when was the phone call?
December 11th.
So they're telling her that the position's being eliminated and you're gone, and they don't give her any other offer for respiratory therapy, and she's qualified for that. The only problem is that she can't continue on because she's still under treatment and unable to work because of her disability.
Well, right? I will let me clarify that. If she had been offered and accepted the respiratory therapist position, certainly she was on leave, and St. Mary's would have worked with her through that accommodation process. But because of her conduct in the call and the decision not to extend that direct respiratory therapist offer to her, her last day of employment was December 11th.
Why isn't it reasonable that her conduct is what it was when they call her up and say the reduction in force is eliminating your position, and even though you're qualified for two other patient treatment positions, it's not being mentioned? Did she ask for it? I mean, did she say, well, why aren't you offering me the other positions? No, they just said, you're out, you're gone today, clean out your desk, figuratively. Yeah, okay. Thank you.
Did counsel answer your question, Commissioner David?
Yeah. I mean, I see where our difference is. Yeah. I got it.
Attorney Milligan, did you want to respond to Commissioner David's question?
Yeah. Well, to say that that the hospital was just like, you're gone, get out, and what have you, is, I don't think, a fair characterization. They worked with complainant and were very accommodating complainant up until this legitimate business decision of the reduction in force. obviously, you know, they did not ultimately extend the offer to complainant, but like all other former employees that their positions were eliminated, they attempted to work with complainant for a severance agreement. And you know, it wasn't just, I just want to clarify that characterization on behalf of the hospital was not just pack up your bag and you're gone, or your desk and you're gone.
I thought you just said that they did ultimately offer her the position.
No.
No, they didn't.
No, they did not.
She must have known through the consultant's study that that was a possibility, that they were looking for administrative, you know, fat, as it were, positions to cut, cost saving measures. Why wasn't it being, it just seems to me that it would have been discussed all the way along that you could step down from this supervisor role to patient care if you wanted to. That's not a question, and I get carried away here. Never mind.
In response to some of the discussion, the investigator informed me that we do not have any direct quotes from the phone call. So just going to head those questions out of the past. We don't have it. Any further commissioner questions for Attorney Gilligan? Okay, seeing none, you'll have a little less than 6 minutes when we come back to you.
Thank you.
Attorney Scott, you have 1 minute and 20 seconds if there's anything else you'd like to add.
Thank you. So as we were just saying, St. Mary's did not produce evidence to demonstrate when that decision was made, how it was made, or corroborating evidence of what occurred on the phone call. They didn't provide affidavits from the individuals who were on the call, even after they say that this Kajanan said she was going to consult counsel, that this was going to be used as the basis for why she was not being offered that alternative position. And again, this, this situation completely contradicts all of her performance evaluations of being calm under pressure, a good communicator. She said it was a very short phone call in which she asked about her protected medical leave at the time. It was pretty short, nothing much else was said. Of course, she was sad and shocked, but there were no raised voices, no threats, nothing of that kind. And again, at the end of the day, the facts are straightforward here. St. Mary's knew about her severe injury, knew about the expected duration, and that she was on leave for 4 to 6 months, and used the ongoing reduction in force as a reason for terminating her without offering her that alternative position, despite, as Attorney Gilligan just said, that they did have a pretty urgent need for respiratory therapist positions at the time. And she was the director of that department and was very aware of those positions, and that she was qualified and licensed to fill that. Thank you.
Commissioner David?
Looking at the 3 counts, you've said that you're not really investing much argument in the age discrimination. The crux of this comes down to question 2, is whether there's discrimination based on her disability. What is your argument for 3, that there's retaliation? Is the retaliation you're saying that she's being fired because she's saying in the phone call, I'm going to get counsel and pursue this? Is that the retaliation?
That's part of it, for sure. And the fact that
I have this argument. I have this question. Okay, Kit.
Commissioner David, please let Attorney Scott finish her answer. While we're managing so much on Zoom and in person, I'm trying to keep everybody from interrupting each other. It makes it very hard to follow what's happening. Attorney Scott, did you want to finish what you were saying, and then Commissioner David can ask his next question?
Sure, thank you. Yes, that was part of the retaliation, as well as the fact she was on protected medical leave, again, for the duration that was known to St. Mary's based on what her providers had told her, and the fact that she had informed them she would likely need a reasonable accommodation when she was to return to work based on her mobility issues at the time.
Thank you. Commissioner David, did you have a follow-up?
Yeah, it just seems to me that that's the. I don't see why it's retaliation. It's discriminatory behavior. That's the discriminatory behavior that she's being. No, I don't have a question.
Okay. Any other commissioner questions for Attorney Attorney Scott. Okay, seeing none, we'll return to Attorney Gilligan. You have 5 minutes and 44 seconds.
Only just to clarify that up until this conversation right here, the conduct during the phone call was never asserted as an element of the alleged discriminatory conduct. It was always the decision to eliminate her position. But I welcome any more questions.
Any other commissioner questions for Attorney Gilligan? Okay. Seeing none, thank you both. And next we'll hear from Alex Brindley, the investigator assigned to this case.
Morning, everyone. I'm Alex Brindley. I investigated this case. Now I want to touch on what I found were the two primary questions here, whether or not the respondent's decision to eliminate complainant's position was discriminatory. And second would be if respondent's decision not to offer complainant the position of respiratory therapist was discriminatory. On my first basis, complainant did not allege in her reports that respondent discriminated against her when it did not offer her the respiratory therapist position. She was not aware that they had not offered her the position until she received the respondent answer. Certainly it was brought up in later submissions, but technically she did not amend her complaint to add that claim. So the primary condition is whether or not the reduction in force itself was discriminatory. Based on what I reviewed, there was definitely evidence of financial strain by respondent. It was mentioned throughout, and there's also in the record a list of complainant's job duties. Primarily, most of them were administrative, based on the reduction in force analysis completed by the consultants that the respondent took in. It seemed that the other manager, the rehab and work med director, could have taken over and was in fact covering that department while complainant was on leave. So at least there was a financial determination in that regard, which I found suitable and non-discriminatory. Let's see. In regards to the analysis that it was based on age, attorney for complainant has discounted that, which you can also find evidence of that in my report, in that she was not, quote, replaced, just the new director was of a similar age to the complainant. In regards to the disability claim, that they chose her because she was disabled / on medical leave. Based on what the respondent provided, they had also fired another individual who was on medical leave during that time. Let's see. Yeah, there was another individual who was on medical leave at that time. But mostly it seemed to me that the respondent's decision the decision to eliminate complainant position was financial in that matter. In regards to the phone call, there were claims about it being inconsistent, the statements that a complainant had made unprofessional comments or conduct during that phone call, and then later the email provided from the supervisor to the HR director that he said he forgot. I did not find that inconsistent. In fact, perhaps both or either occurred in this case. Regardless, either her alleged unprofessional conduct and or forgetting to offer her the position of respiratory therapist is not discrimination based on age and a disability in this case. That was a lot. I'm over it.
Yeah, Sandra. Thank you so much. I appreciate your effort here. There's just one piece of the timeline that's a little bit murky to me, and I'm hoping you can clear it up. On the bottom of page 2, paragraph C, you start laying out the timeline, which is really helpful. The report reflects that at some point in October of 2023, there's notification that this is going to be happening, and then there's 129 positions identified. Do we know Was it at that time that the complainant's position itself was identified for elimination, or did that happen sometime thereafter?
Sure. So my knowledge of how they made that decision is limited. What I do know is that of the 129 positions that were eliminated, only 31 ended in job termination. I don't know when exactly that happened, but
Yeah, I'm really trying to get at in my mind. So that was happening in October, so planning, and then on October 31st, pretty soon thereafter, it appears that the complainant was involved in an accident. I'm just trying to understand the relationship between when was the complainant's position itself identified for elimination?
Sure.
Prior to the accident or after the accident? Do we not know that?
I don't think that's in the record. Attorney Scott, the complainant's attorney, did mention that complainant was aware that a reduction in force was happening, but I don't believe at that time she was aware that her job was in.
Yeah. Any other commissioner questions for the investigators? Thank you, Alex. All right, so we've heard from the parties and the investigator. At this time, we are looking for a motion. There are 3 proposed findings.
I'll move that we accept the investigator's report as written. 1, there are no reasonable grounds to believe that St. Mary's Regional Medical Center discriminated against the complainant on the basis of age. 2, there are no reasonable grounds to believe that St. Mary's Regional Medical Center discriminated against the complainant on the basis of disability. 3, there are no reasonable grounds to believe that St. Mary's Regional Medical Center retaliated against the complainant for engaging in MHRA protected activity, and that the complaint should be dismissed in accordance with 5 MRS section 4612 sub 2.
Second.
Moved and seconded. Any discussion? Being none, the motion is to find no reasonable grounds on all 3 recommended findings. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Sanders? Yes. Okay. So the findings are no reasonable grounds. We thank everybody for their participation, and the commission will send a letter to the parties confirming the results of the hearing.
Thank you.
Could we take a 5-minute break?
Okay.
Right, and in that time, Commissioner
Always did. Okay, ready for the next case?
Ready.
The next case is E 240173, Christian McCory versus Broughton Hotel Corporation. It is a recommendation for a finding of reasonable grounds on the disability count and no reasonable grounds on the other two counts. Given the recommendation for a finding of reasonable grounds, we will hear from in presentation first from respondent.
Still good morning. Will you tell me how to pronounce your last name, please?
Good morning, Commissioners. My name is Attorney Cecilia Shields Albo.
You have 10 minutes whenever do you want to reserve any of your time?
Yes, 2 minutes, please.
Okay, whenever you're ready, go ahead.
Good morning, Commissioners. I represent the Colony Hotel in this matter, the respondent, and I'm here today to argue that there are no reasonable grounds to believe that the Colony Hotel discriminated against Christian McCory, the complainant, on the basis of his disability. Specifically, that this commission should set aside the investigator's recommendation to the contrary, because Mr. McCrory can't make that prima facie showing of all of the elements of disability discrimination under the Maine Human Rights Act. As this commission well knows, there are 3 elements to unlawful discrimination for disability under the MHRA. First, the complainant has to establish that he suffers from a disability, which we don't dispute in this case. Second, that he is otherwise qualified and able to perform the essential functions of his job. And third, that he was adversely treated by his employer, at least in part based on his disability. So respondents in this matter disagrees with the investigator's analysis of the last 2 elements, which I will address in turn. To begin with, Mr. McCrory wasn't qualified or able to perform the essential duties of his job. By way of background, the Colony Hotel is highly seasonal, located in Kennebunkport. It's only open for about 5 months of the year, from mid-May to mid-October. It's often sold out every single weekend, and its busiest time centers from July 4th through Labor Day. And as for Mr. McCrory, the investigator gave us a great, excellent summary of his role at the hotel. She found that he is the Colony Hotel's only general manager, and his essential job functions include but aren't limited to managing the entire staff, executing payroll for the hotel, handling guest complaints and issues in a timely way, and enforcing the hotel's policies and procedures. So in this case, Mr. McCrory has a burden of establishing at a minimum that he was qualified for his role as GM. And 2 of the most basic qualifications for really any position of employment are attendance and the ability to perform the job's essential duties. And those 2 components are inherently related, because you can't perform your job if you don't show up to do it. And the record in this case plainly shows that Mr. McCrory couldn't perform the essential duties of his job because of how often he wasn't there. The investigator indicated in her findings that Mr. McCrory missed several critical shifts in the summer of 2023, and all of them were unrelated to his disability. They were related to childcare or other family-related issues, for example. On May 24th, over Memorial Day weekend, he was a no-call, no-show because of childcare. Over the 4th of July weekend, he missed several shifts that he was a no-call, no-show for because of a family emergency. And at that point, the investigator found that Mr. McCrory's supervisor started taking over the general manager responsibilities, questioning Mr. McCrory's reliability, including whether he should continue to serve as the hotel's only general manager. He was also a no-call, no-show on July 20th for childcare reasons. And then finally, on July 26th, he was a no-call, no-show on a day when payroll was due, which was his responsibility alone. And so his supervisor once again had to step in to ensure that the hotel staff got paid. In fact, Mr. McCrory didn't respond to his supervisor's repeated texts about his absence that day until about 7 p.m. And at that point, he disclosed his disability. Now, when the investigator was evaluating Mr. McCrory's ability to perform his role as the GM, she opted to disregard this history of no-call, no-shows on the basis that the hotel hadn't formally disciplined him for those absences until after he disclosed his disability. And this formal discipline that she's referring to is a letter dated August 4th, written by his supervisor, that pertains to his absences over July 4th and Memorial Day weekends. Not accounting for Mr. McCrory's pre-disclosure absences is problematic for two reasons. To begin with, Mr. McCrory was well aware that his absenteeism was a problem for the hotel. He testified at the IRC hearing that he was a no-call, no-shows several times in June, in addition to the documented absences in July that I just described. And he stated that he discussed his absenteeism with his supervisor as early as mid-July. This testimony supports the investigator's own findings that by early July, that supervisor had started questioning Mr. McCrory's reliability and whether he was the right person for the job as GM. And the fact that the hotel didn't formally document its decision to discipline Mr. McCrory until August 4th, which was just over a week since his July 26th absence, doesn't justify ignoring his failure to perform his job during the height of the hotel's busy season, which is why he was ultimately demoted. And critically, the role that Mr. McCrory had at this hotel included responsibilities that, if not completed, would negatively impact the guest experiences at the hotel, as well as the employment conditions of the rest of the staff. And it exposed the hotel to labor violations for failing to timely pay its staff for the work they've done. Now, as to the last element, Mr. McCrory was demoted because of his absenteeism. And the Colony Hotel strongly disagrees with the investigator's conclusion to the contrary, that, and there's a few reasons why her reasoning on this issue was flawed from our perspective. First, she noted that Mr. McCrory had missed a few shifts before the end of July, but stated that the majority of his absences started on July 28th and they were related to his disability or treatment that he received for it. As I mentioned earlier, the hotel formally documented its decision to demote him in a letter dated August 4th, and that letter only references absences that started July 26th or earlier. So focusing on absences that started on July 28th isn't pertinent to the reasons why the hotel demoted him. What is pertinent is his pattern of no-call, no-shows during the busy season. And we know the investigator expressly found that his supervisor had started taking over his functions in early July as a result of that absenteeism, questioning whether he was reliable, considering whether he should continue in his role as GM. So to characterize his absences as a few missed shifts really confusingly downplays how significant it was that he was leaving the hotel and its staff high and dry during the height of the summer. And second, the investigator entirely disregarded the written warnings that were in Mr. McCrory's personnel file that his supervisor had issued as a result of these no-call, no-shows. And she did so because Mr. McCrory hadn't signed them and he said he hadn't received them. But whether or not he received these items in his personnel file or signed them doesn't speak to the hotel's earnestness in its decision to demote him. And these written warnings are strong evidence of that they were demoting him because his absenteeism had led to the fact that he could no longer be relied on to perform the essential functions of his job. And lastly, the investigator indicated that Mr. McCrory's supervisor never made any statements to him about reliability after any of these absences. And that's directly contradicted by Mr. McCrory's own testimony that he discussed his absenteeism with his supervisor in mid-July, as well as the many texts between he and his supervisor, where his supervisor is wondering where he is and why he isn't doing his job. In sum, respondent proposes that the evidence here shows that Mr. McCrory's absenteeism made him unable to perform the essential duties of his job as GM. And
Attorney Shield, that is 8 minutes. Do you want to keep going?
Yes, thank you. And the hotel's decision to demote him was based on his lack of reliability, not on his disability. So we asked this honorable commission to find there's no reasonable grounds to conclude that unlawful discrimination occurred in this case. Thank you.
Commissioner questions? Commissioner Douglas.
Yes. Good morning. I have to check. So let me preface this question by saying that so we're all on the same page. Someone close to me has run one of those inns right down the street from the Colony. So I'm intimately familiar with what goes on down there in the summertime. And that said, I'm absolutely baffled by the fact, and I'm hoping you can help me out here. This guy missed a bunch of shifts over the July 4th holiday. at the Colony? I mean, you said something about written warnings and things, but what I'm seeing in the report is basically he wasn't disciplined for that. How is this possible, right? I mean, my understanding of the situation of a place like the Colony in that neighborhood has been an absolute disaster, right? And he's the GM, so help me out here.
Thank you, Commissioner. That's a great point to discuss because as you can see from the text messages, the supervisor was communicating to Mr. McCrory that it was an operational trash fire. There was a lot going on at the hotel. It was fully booked starting on July 3rd. It's their busiest weekend of their entire season. And I can't speak to why this particular supervisor didn't sit down with Mr. McCrory more formally to go over it. He did issue the written warning and put that in his personnel file. And there's a lot of text message conversations going back and forth about when he's going to come in, why he's not coming in. The supervisor does text him and say it would have been nice to have known earlier that he was not going to make it in at all. But it's important to also view this in the context of the fact that he was absent because his mother was in the hospital for a second heart attack. So there was a little bit of that personal aspect in here as well. And Mr. McCrory is an employee who worked for the Colony Hotel for 5 years prior to this, this term of employment. So he was a known entity to the management.
Okay. And if it's in the record, if he didn't have these absentee issues before this summer that we're speaking about?
I don't have anything in the record about that. There is a string of text messages from 2022 in October, I believe, where he asks for the day off prior to his shift starting, and does take the day off, but that's all I can present. Otherwise, we're really just focused on his absences that were starting in May of 2023 over Memorial Day weekend.
Yeah. Okay, all right, thanks.
Commissioner Sanders?
Thank you. I'm curious about these text messages towards the beginning of August. The investigator draws our attention to them as part of the rationale for the finding of reasonable grounds. And these text messages reflect the supervisor and the complainant, talking about the disability, the need for treatment, and in particular, one of the text messages reflects, quote, "There is no pay without the recovery program." So I'm curious, where does that fit into your analysis, and your argument this morning, your belief, right, that the respondent has no liability here, right, did not engage in discriminatory conduct? Don't these text messages reflect, yeah, we should be making a fair inference that that's in fact what's going on?
The supervisor's insistence on Mr. McCrory receiving treatment wasn't something that we're contesting was proper in this case. But what these text messages do show is that the conversation between Mr. McCrory and his supervisor was focused on what capacity he could possibly come back to the hotel in, because he, starting after July 26th, hadn't come back in for a shift. And so the conversation was really about, okay, well, there's a ton of childcare issues, which has been an issue in the past. There are a lot of the no-call, no-shows that have left the hotel high and dry. There's a loss of trust. The staff has been left without their leader in those circumstances. So how can I possibly expect to bring you back now that I know you have additional scheduling conflicts too? So it was about the prior conduct. And I can point to a few of those text messages actually. For example, Mr. McCrory on August 3rd texts and says, "But seriously, have I ever been a liability on the clock?" And that's not an issue, as you can see by the supervisor responding saying, "Seriously, not showing up is a problem." And earlier in that same thread, the supervisor says, "I worry you don't appreciate the situation you've put us in twice. I cannot say that we fully recovered from last Tuesday or Wednesday," which was the July 26th no-show, which resulted in payroll being late and improperly done, actually. So he says, "Help me move forward toward confidence that we can count on you." And when Mr. McCrory responds and says, "What do you need from me?" the supervisor says, "I've asked you to communicate with me, but I'm not getting that when you don't show up for work." So this is reiterating that the problem was he was no longer reliable enough to actually get the job done. And the team at the Colony Hotel needed that to get through the busy season.
Thank you. Any other commissioner questions? Okay, seeing none, you'll have 1 minute and 46 seconds left when we come back to you. Attorney Hanson, good morning. Nice to see you in person.
Thank you. Yeah, nice to see you all as well.
Kyle, do you want to reserve any of your time?
2 minutes. Thank you, commissioners. My name is Chad Hanson. I represent Mr. McCrory in this matter. I think I want to start by talking about what the standard is in these cases. It's whether the protected category was a factor that made a difference, not was it the sole factor, the only factor. These cases are complex and there's often a lot going on. There's a lot going on here. But in this case, we've got, let's say, the trifecta of evidence. We have the timing, we have the animus from the manager, and we have pretext evidence. The timing is glaring because we have how they're handling the situation before he discloses his disability and how they're handling it after. And it's a stark difference. Commissioner, as you point out, not being there on 4th of July in this area, in this job, can be a big deal, or it is a big deal for a general manager not to be present. But they weren't writing him up. They weren't terminating him. He is a 5-year employee. He was a general manager that did well. And so I think that's telling that there was no plans to push him out of his job or do anything. There's no discipline, and we can talk about that. There's nothing in writing because at that point, they weren't planning on letting him go. And you can see that as soon as his family notifies about his disability and his need for leave, then all of a sudden we're hearing things like your reliability. I'm concerned about, can we trust you? His employer getting involved in dictating what his treatment needs to be for him to be able to come back, which is a huge red flag in a disability discrimination case. And so the before and after is stark. And I think that's when we're talking about these write-ups and the claim that he was demoted secretly before he went out, it kind of dovetails into the pretext piece. He wasn't written up. He wasn't shown these write-ups. He wasn't told that he's being counseled or warned or anything like that. We didn't see these write-ups. When the respondent submits its submission to the commission, it doesn't mention them. It doesn't attach them. It's only afterwards, and we had asked for the personnel file back in 2024, it wasn't provided. It's the first time we see all these write-ups. And so a reasonable fact finder could conclude that the respondent created them to try to explain things. But if a fact finder is concluding that they created these things that he never saw, why are they creating things? Why are they trying to create a record that they didn't have already? I mean, A, it's terrible HR, but B, it's just not credible. And so the fact they're coming up with those, there's this letter on August 4th that the respondent points to. That was never sent to Mr. McCrory. He didn't see that until after we're in the midst of this. And so all this stuff is created after the fact to suggest that they were already treating this in this way, when in fact, they didn't start treating it like a disciplinary issue until after Mr. McCrory disclosed his disability and disability. And so there's the pretext. And then, like I said, the animus, where they're dictating to him what sort of treatment he needs to get before he'll be trusted and allowed to come back. And so focusing on those things. And I think the secret demotion, the claim is that Mr. McCrory didn't know it, but he was replaced as the general manager because no one was telling him. And that doesn't make sense, because even if he's absent for a good reason, like his mother's health or because he can't get childcare, he's still behind the scenes. He's communicating with his assistant manager. He's getting things done. And that's what he did right up to the time that he went out for treatment. And so the suggestion that he was secretly demoted and he just wasn't told, and I think that has more to do with the FMLA claim, because he does have an FMLA claim, and the fact that if you go out and leave and you have a job and you come back and you don't have a job anymore, well, then the employer argues, well, maybe we demoted him before he went out. And so I think that's really more relevant to that issue. But it just goes to the credibility, and from the perspective of a fact finder and the standard of an even chance, we believe that the investigator got it right when they found that there was reasonable grounds to believe that there had been disability discrimination. And with regard to the other allegations, we didn't file an objection, so those aren't disputed.
want to make sure I heard you right. So my understanding from your presentation here is that at some point, your client, either with your assistance or otherwise, requested his personnel file and received the file. And these write-ups that we've been discussing this morning were not in the file.
Almost. We asked for the file in May 2024, after he resigns, after his pay is cut, et cetera.
As we do at the beginning of the case.
Yeah,
right?
that's what we always do. We ask for the personnel file because we want to see what's in there, and we want to see what's not in there. So if things pop up later, we can say, well, look at the file you gave us, but they didn't give us the file. And so they didn't give us the file until after the respondent submitted their RA, their respondent submission. So the timing is ask for the file, don't get the file, respondent gets the charge, responds to the charge, doesn't reference the write-ups or the letter, doesn't reference any of that or provide them. And then afterwards, the respondent produces them for the first time in a supplement to the response. And then the respondent provides the personnel file. So when we actually receive it, like a year, when we receive it later, put it that way, then they're in there. But the point is they weren't in there, we didn't get it, and they weren't mentioning them in the context of this investigation. So what we would argue is that a reasonable fact finder can conclude maybe they're created, especially on Mr. McCrory saying, I've never seen these things before. Like we weren't having this conversation. So
okay, I'm with you. Thanks.
Any other commissioner questions for Attorney Hanson? Okay, seeing none, you'll have Attorney Shields-Avila, you have 1 minute and 46 seconds.
Thank you. I'll start by addressing the allegation that there was this secret demotion going on. That sounds very nefarious. It was not secret. Mr. McCrory was scheduled to meet with his supervisor on August 4th to discuss whether or not he would continue in his current role, what his employment at the hotel would continue to look like, and he didn't show up. And we know why now that occurred, but there was no secret demotion happening. He just didn't show up for reasons of his disability, which we now know that we have the full record. And as I've discussed, the August 4th letter memorializes what the supervisor had intended to discuss with him that day, which was the fact that his absences over the 4th of July weekend and on Memorial Day had left the hotel high and dry, and he was no longer fit to serve as the general manager. But he would come back for a probationary period in a less demanding role, which he did so eventually. And as for opposing counsel's suggestion that these write-ups were fabricated in some way, there's just no evidence to support that. It was a procedural delay getting the documents into the commission. And as you can see, they directly reflect all the testimony in this case and the investigator's findings that Mr. McCrory was in fact a no-call, no-show on those dates. I will answer any further questions from the commission.
Yeah, I just have to come back to this nefarious personnel file just a little bit, because there is a statute, as we're all aware, right, where an employee can request their personnel file. And there's a very short window of time to produce that. And if I'm understanding correctly, what I'm hearing is that was not produced until this proceeding, at some point in this proceeding, which I think does sort of call into question, you know, the authenticity, shall we say, of the August 4 document and some of these write-ups that we've been discussing. So I want to give you a chance to address that in fairness.
Thank you. Yes, at that point, I myself personally was not involved in the case, but it's my understanding that the firm that had this case prior to my firm had an open extension to produce the personnel file. And then when our firm was subsequently asked to produce it, we did so. That's why there was a procedural delay involved in this case.
Okay. All right. Thank you.
Thank you.
Any other commissioner questions for the respondent? Seeing none, Attorney Hanson, you have 5 minutes and 47 seconds.
Unless there's questions, I don't have anything.
Further commissioner questions?
Was there an extension to produce the personnel file?
The prior firm indicated they would need some more time, but we certainly weren't agreeing that they could wait for months and months and months.
Right. There's a statutory deadline, right?
Yeah, it's
10 days.
10 days.
Yeah. All right. Thank you.
All right. Thank you both. And next we will hear from Nupur Leva, the investigator assigned to this case.
Good morning, Commissioners. So this case I really struggled with. I talked about it with Jane a lot as my supervisor. I definitely struggled with this. At the end, the parties were both credible, and it did seem like a lot of the reliability issues only arose after Mr. McCrory sort of disclosed his disability. That combined with sort of conditioning his return on receiving treatment was what sort of not swayed me necessarily, but led to my conclusion that it was just as likely that he could succeed at trial and meet our standard of 50-50. So I found in his favor.
Commissioner, questions for the investigator? Commissioner O'Brien?
Just that, and maybe it's not fair to ask you, but it's fair to ask you this. But I believe that I recall Barbara saying at one point, sorry. At one point, I asked this question about that, yes, alcoholism, and I can say that because it was in here, is a disability, which, but it's the conduct that's when it becomes a problem. So am I correct in that?
Alcoholism is a disability per se,
right?
Which doesn't mean you have to allow people to drink on the job or show up drunk. And they still have to be able to perform the essential functions of their job.
Okay.
With or without a reasonable accommodation.
Okay. Okay. Well, another thing that struck me is that it appears to me, correct me, that there were no issues before. He didn't have write-ups before until he disclosed his disability. Am I right? Did I hear that? Okay, well, disclosed disability is because it appears to me that it had a flare-up, so that's why you know what I'm trying to say.
I'm sorry, I don't quite understand.
Right, well, Tom's nodding. Okay, thank you.
I understand. I know where you're coming.
Yeah.
That's really all that matters.
It is.
Any other commissioner questions for the investigator? Okay, seeing none, thank you, Nooper.
Thank you.
We have heard from the parties and the investigator. At this time, we are looking for a motion. There are two proposed findings.
One of which is uncontested. That one should be.
Okay, great. So you can take them separately if you'd like.
Well, let's just do the.
Let's take them together and move that we adopt the investigator's recommendations as written. One, there are reasonable grounds to believe that Fountain Hotel Corporation, DBA The Colony Hotel, discriminated against Christian McCrory on the basis of disability, and conciliation of this claim should be attempted in accordance with 5 MRS section 4612 subsection 3 and 2. There are no reasonable grounds to believe that Fountain Hotel Corporation, DBA The Colony Hotel, retaliated against Christian McCrory for engaging in MHRA protected activity, and this claim should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Second.
Moved and seconded. Any discussion?
Yeah, I agree with Nooper. I think it's a really tough case, and I think it's been well argued. And I it just, the facts of that summer of 23, I think, I have to come back to the even chance standard. I think that I understand what the colony's position is, and I understand what Mr. McCrory's position is. There are aspects of both that are troubling, but while I think that the discrimination claim is subject to even chance standard, I think it could probably go either way. So
This is very difficult for me. This is a real tough one for me. So I think, I don't know what I'm gonna.
Any further discussion? Seeing none. The motion is to adopt the findings as written. Give Julie a little time and go
No,
back. I know, I'm
just
gonna
go
find
whatever
whatever.
happens.
Right.
Yeah.
So reasonable grounds to believe that respondent discriminated against complainant on the basis of his disability, and that claim should be conciliated. No reasonable grounds to believe that respondent retaliated against complainant for engaging in MHRC protected activity, and that claim should be dismissed. If you are in agreement with that motion, you will vote yes. Commissioner David.
Yes.
That was a yes?
Yes.
Okay. Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
Okay. The findings are reasonable grounds. The commission will send a letter to the parties confirming the results of the hearing, and we thank you both for your participation.
E240224 Matthew Williams versus Maine Bureau of Human Resources is a recommendation for a finding of no reasonable grounds. We'll hear first in presentation from complainant.
I am recused myself in this matter.
All right, Attorney Morris, I'm just going to let Commissioner Sanders find her seat. You have 10 minutes. Would you like to reserve any of your time?
Thank you. I won't take my 10 minutes, so I would be happy to reserve whatever is left.
Okay, whenever you're ready, go ahead.
Thank you. Good morning. We're still in the morning. Good morning, commissioners. I represent Matthew Williams, who is a former state trooper, and his claim against the state of Maine. This case at this point presents a relatively narrow issue. There is not a dispute that Mr. Williams is a qualified individual with a disability, that the state knew of his limitations, that he requested an accommodation to a day shift position because sleeping was particularly important to his recovery from PTSD symptoms, and the state denied that request. The disagreement is over whether the state met its burden to show that accommodating him would have caused undue hardship. And I think this case presents sort of an interesting procedural posture in that sense, and that, of course, we are the complainant and we have initially the burden to prove our case. But in this case, the state is saying that the accommodation request that was denied would have caused an undue hardship. And the state actually has the burden to prove the undue hardship. And here, we think there is, because the support for the undue hardship was presented in the sense of a theoretical description of how the staffing works, rather than specific evidence of what the hardship would have been, that the state did not meet its burden of showing an undue hardship. Stated another way, the fact that there is a seniority system in a signing shift alone is not sufficient to show undue hardship. There's a couple of things that also have to be considered. One is whether that seniority system has exceptions to it, and that's under the case law primarily relied on by the respondent. And then the other issues relate to whether the alternative accommodation offered here addressed the problem that the night shift was creating for my client. And then there has to be a way to analyze whether this seniority system in fact prevents my client from being assigned to a day shift. So here, there is no employee identified that it was allegedly displaced. There's no shift that the employee allegedly held that created the undue hardship. There's no specific contractual right allegedly violated. There's no evidence of the actual staffing calculation requirement for displacement, and there's no evidence about why a vacant day shift slot could not be used for an accommodation. So our view is that the assertion of undue hardship here is only supported by a theoretical computation of how seniority works, and that therefore there is not sufficient evidence that meets the undue hardship standard. So we don't know that a seniority system was bumped. We don't know how many troopers there may have been who had more seniority, who could have gotten the slot that my client was asking for. And we don't know whether all of the slots available on the day shift would have been filled with more senior troopers. So I just want to address for a minute the alternative accommodations. My client was offered an accommodation with respect to having no midnight shift, but the Troop G schedules included midnight shifts, and that would have led him in the same predicament. Additionally, the Southern Field Troop accommodation was not a day shift accommodation and a similar schedule, and so that would not have addressed the accommodation he was looking for. And then finally, the inversion schedule, that was not a stable accommodation. It was something that could happen on an ad hoc basis, so he was still subject to working the shifts that exacerbated his disability. My client did submit information that showed that there were vacant day shifts. And again, there was a theoretical discussion of whether these day shifts would or could be filled, but not some actual evidence of displacement of a seniority system. And then finally, the U.S. Airways versus Bennett case talks about exceptions to where a seniority system is changed, applying a way that reduces employee expectations that seniority will always be followed. And the inversion shift on that alone indicates that there were changes to that seniority system. So again, I think it's a narrow issue. And the question is really, has the state, or our position is that the state has not come forward with actual evidence of undue hardship in this case. And so therefore, there is reasonable grounds to believe that discrimination has occurred. I'm happy to answer questions if I can.
Commissioner, questions for Attorney Morris? Commissioner Douglas?
Yeah. Good morning, Sally. So I'm just looking at the report. I appreciate your argument about the seniority, and I read your submission, and I have been with the Barnett case. The report, however, the investigator's report seems to more, and maybe you're talking about the same thing, I just want to clarify, more seems to focus on this business of covering both day and night shifts, right? So if they move your guy into a day shift, then there's a night shift that needs to be covered, and there's a balancing. And so I just wanted to make sure that we're dealing with, yeah.
Right. You're referring to page 4 of the report?
Yes.
Yeah. Yes. I think there's it's a two-part answer to that question. One is that my client submitted evidence indicating, or he presented a factual dispute indicating that there was an ability to move to day shift. And then the response to that is sort of the hypothetical of how the assignments applied. So one, I think there's a factual dispute. And then 2, the response to the factual dispute is not actual evidence. It's well, this is how this works. If you move A to B, then C, and then D. And we still don't know who would have been displaced and were they more senior.
I read at some point in the report that your guy actually identified an open shift, right? An open day shift. And he was told he couldn't have it because of this hypothetical reasoning, as you call it.
That's right. I mean, he presented documents that had, I'm sorry, did I interrupt you?
No.
Oh, good, okay. Yeah, we presented documents that showed the vacancies in the shifts.
Okay. All right, thank you.
Any other commissioner questions for Attorney Weavers? Do none, we'll have 3 minutes and 49 seconds when we come back. Attorney Parker? Just barely, good morning.
Sneaking it in.
Would like to reserve any of your time.
Whatever I will. Good morning, commissioners, commission staff. Thank you for hearing me. My name is Jeremy Carter, Assistant Attorney General representing Bureau of Human Resources on this case, the Maine State Police who we're dealing with here. First and foremost, I think we have to establish what the standard is because we do not accept or do we agree with what complainant has just stated. This is one of the rare cases where we actually get a case from the United States Supreme Court that is pretty directly on point with the Americans with Disabilities Act and thus the Maine Human Rights Act disability provisions. That's not common. We're usually fighting over squabbling circuit opinions. Here we have the United States Supreme Court in Barnett that does not say that a violation of the seniority system is an undue hardship, which is what Attorney Morris has just argued. It's that it's unreasonable on its face. Companies, employers don't have to get into undue hardship when it comes to violation of a seniority system. It is enough that it violates it to say it is unreasonable. I can quote you in our submission at 405 of that opinion, the court wrote, "We can find nothing in the statute that suggests that Congress intended to undermine seniority systems this way, and we consequently conclude that the employer's showing of a violation of a seniority system is by itself ordinarily sufficient to deny an accommodation." Further, the Equal Employment Opportunity Commission, in promulgating the regulations on that fact, says generally it will be unreasonable to reassign an employee with a disability if doing so would violate the rules of a seniority system. So I know those two lines can sometimes blur and merge together and cross undue hardship versus just sort of facially unreasonable when it comes to accommodations. But our argument on this is that it is and always has been facially unreasonable because it violates a seniority system. So when Attorney Morris talks about us having to show some burden on undue hardship, it's never been our argument because both the courts and the EEOC, the federal courts and the EEOC, which are certainly persuasive authorities here, have never suggested it's a question of undue hardship. Though we do appreciate Investigator O'Reilly did some of that analysis as well, and we certainly don't disagree with it. But that's just sort of a disagreement on the standard here. Now, as this works, Mr. Williams wanted to work the day shift. He was in Troop G. Troop G polices on 2 shifts. It was 12 to 7 and 12 to 7. 12 to 7 and 7 to 12, I should say. They cover from Kittery to Augusta on the Maine Turnpike. It is very important, obviously, to have sufficient staff on the night shift. Obviously, also, many people, many troopers, particularly if they have families, if they have children, they don't want to work the night shift. They would much rather work a day shift. And therefore, there is always going to be more people who want the day shift than the night shift. So the state police offers a bidding system. The more senior employees get the first dibs. And unsurprisingly, those day shifts go quick. But what happened here was that Mr. Williams left and came back to state service. So his seniority fell back down to the bottom. And he was still pretty low at the time of this dispute. He wasn't really anywhere near senior enough that there was much likelihood he'd nab the day shift. Now that said, Troop G, which is the one he worked for, ideally would have liked to have had a lot more troopers on both day and night shift. It's understaffed. It's a chronic problem with state government right now. It's hard to find people. They are short on troopers. They would have loved to have more. So ideally, they could have had more people on day shift. And that's what I believe Attorney Morris is alluding to, what Mr. Williams pointed to. He said, there's a vacant shift on G, but the state police had to say, well, yes, it's vacant and we'd like to put someone there eventually, but we can't put you there because you already work nights and we need you there. So it's about how do you divide a already limited resource. If Mr. Williams had been taken from night shift and put to day shift, they would have had to replace him at night shift. Who would the available pool have been to do that? Well, it's no one else on night shift. They're already working. So if Mr. Williams was to be replaced, we'd have to go to day shift. and tell one of the day shift people, you're going to night shift. All the day shift people are more senior than he is. That's how they got that gig. That's why he didn't. So there would be no way to move Mr. Williams to the day shift without telling someone else, more senior than he, you have to go tonight. Or I suppose the alternative would be for the state police to say, well, we'd like another trooper there, but we just can't, we're not allowed to. We're not allowed to have a trooper there. And that's not what the ADA envisions. That's not what the MHRA envisions, particularly when it comes to public safety, that it's supposed to hamstring employers in ways like this when it comes to making reasonable business decisions, or in this case, reasonable public safety decisions. As to the inversion shift, as Attorney Morris mentioned, the inversion shift is not being an appropriate accommodation, and we never said that it was a total fix to his problems, but it was something we could do in the interim as it was being figured out. It also is not an exception to the general seniority rule. Investigator O'Reilly, I think addressed that pretty clearly in the investigator's report, just because on some days we were willing to say, well, we know you'd prefer to work day. We happen to have someone out sick today. We're going to have someone out sick anyway. You want it for the day? To suggest that that is an exception or a regularly practiced alteration to a seniority system is just not true. In fact, all told, Mr. Williams was a state trooper for about 15 years. He could have named any of the dozens or hundreds of coworkers that he worked with who didn't follow the seniority system. If he could have done that, he might have been able to show there was a seniority exception that we weren't following, we weren't abiding by, but he can't. He didn't name any other coworker throughout his 15 plus years as a state trooper that got to jump or skip the seniority system or didn't have to follow it, which certainly suggests that we did find, it was our assertion, and they offer no evidence to the contrary, that there are exceptions to the seniority system. Every state trooper knows it well, because it has a lot to do with how they work, where they work, and when they work. And they're all eagerly anticipating the day, I won't say all, but most are eagerly anticipating the day they are senior enough that they can be one of those ones who picks their shift. It's kind of open choice. Mr. Williams unfortunately wasn't there at that point. He resigned. He was not terminated. He was not let go. He resigned while he was on medical leave. There was never expression to him we weren't going to work with him further on this. But there was a recognition we couldn't displace someone more senior than he. I will also add that there may have been day shifts available in the other troop that wasn't mentioned was Troop J, the commercial vehicle inspection troop. It's not traditional state trooper work. But there's no evidence the record Mr. Williams wanted that, though that might have been a solve to his problems, but he resigned before that was ever discussed. So I'm happy to take Commissioner's questions.
Questions for Attorney Curtis?
Yeah. Good afternoon. So I just want to make sure I understand. Sorry, I appreciate your presentation. There's an open day shift. That's what Attorney Morris is talking about, right? All the cats that are senior to complainant are already working day shifts.
Yes.
Correct. All right. And there's an open shift. Am I right?
I would say no, it's not open in the sense that they're not looking to fill it because they don't have enough people.
But it's not filled yet.
It's not being filled. It's a hypothetical spot that might be filled in terms of how large they would want the troop to be. But no, it's not filled at the moment.
Okay. So we got a guy that's looking for a day shift. And we got a bunch of guys that are senior to complainant who are already working day shifts.
Right.
And then we've got, I'm not sure what this means, but a hypothetical day shift that could be filled.
Again, this is why Attorney Morris has criticized us for using the analogy or using the hypothetical, but it's much easier to understand. What I used was in my submission was imagine Troop X. It has the potential for 20 troopers. That's the max. 10 day, 10 night. But they only have 16 troopers. They're 4 short. So they go 8 day and 8 night. Now one of those 8 on night could look and say, hey, there's 2 open spots on day.
I understand. So you're saying that if we move our guy complainant today, there's then nobody to fill that night.
Except someone more senior than him. We'd have to take someone off day.
Okay.
Because everyone more junior than him is already working nights. So it would only be something, it's not hypothetical. It's the only possibility is that it would be someone more senior than him.
All right, I'm gonna continue to think about this.
Okay.
Thank you.
I'll be back up.
Try to be.
Any other commissioner questions for? And you'll have, that's what happened.
Thank you.
Attorney Morris, you have 3 minutes and 49 seconds.
My fault.
Just a couple things. One is just looking again at page 4 on the investigator's report. The investigator states, ultimately, though complainant was able to show that respondent denied his request for a reasonable accommodation, his claim fails because respondent successfully established that transferring complainant to the day shift created an undue administrative burden. So I guess I would just respectfully disagree that our argument about the burden is incorrect. And that's what the investigator concluded. That's what we're here challenging. It is twofold. I will agree with that. The question is whether the adherence to this seniority system was unreasonable in the facts of this case. And our position is that we presented facts to create a factual dispute at this point in time that should support a reasonable grounds finding. Secondly, with respect to the seniority system, Attorney Carter's description just explained why the burden wasn't met. We don't really know if there were 8 on the day or the night. There wasn't any evidence submitted to indicate that. It was just, well, let's assume we have 8 and we assume we have 8 at day, 8 at night. If we move somebody, it means we have to take a more senior position. But I mean, we presented to a vacant position and we don't have how the numbers shake out. So I'm again happy to answer questions.
Commissioner, questions for Attorney Morris? Commissioner Davis?
Attorney Morris, are you saying that, well, you just said that it's not an undue burden to violate the seniority system, right? You are saying that they should have taken somebody that was working nights and said, you have to work where complainant's working nights because we're putting him on days.
I'm actually saying something I think slightly different. I'm on this record. What we have before the commission on this record is that the investigator concluded that my client failed to show reasonable grounds because the state showed undue burden. And what I'm saying is the facts in this record are we pointed to an open position. The state is saying hypothetically we would have to move somebody, but we don't actually know who staffed what positions or how many there were. And so without that kind of factual evidence, our position is they have not met, the state has not met its obligation to show undue burden.
So you're saying that it might be the case that they have people working days and nights in equal number, and then they have one more position in which somebody volunteered to be nights, so the day shift is open and they wouldn't give it to complainant, right?
I mean, I think somewhat that's what I'm saying. I think what I'm saying is we don't have facts to know if there are 8 and 8 out of the 16 or if 12 and 4, how it shakes out. And so without that information, we don't know.
I respectfully think we do know. They're telling us. That's what's in the record. That's the evidence.
They didn't present evidence, with due respect, Commissioner. They presented a hypothetical argument. We do not have any information about who occupied those positions.
Okay. Oh, I'm sorry. There was one other question. Do you agree with this Supreme Court case that showing that the violating seniority is equivalent to an undue burden?
No, I think that case says, as Attorney Carter pointed out, that it can be unreasonable, which is not the same thing as undue burden. It can
Okay, well, that's the question then. Is unreasonable not the same thing as undue burden?
I would say no. That's my view, and I don't think that's what the US Airways case says.
Does council have a comment on that? Or can I ask you that?
You can, but you should give me a minute to think.
Okay, fair enough.
Commissioner Douglas.
Yeah, go ahead. No, go ahead. Go ahead, Tom.
I'm gonna go ahead then. So I mean, look, I think if I'm understanding this correctly, putting this together as this argument's going on, it's very interesting. So I think the argument is that in order to put your guy on day shift, right, there was then nobody to cover his night shift. And all the guys on day shift are already senior to him. So they'd have to move somebody from day shift to cover night shift, right? And that violates the seniority system, and that's why Attorney Carter doesn't feel like he needs to say anything else, right? He's got the Supreme Court case, which sort of sets out the standard, and that's it. And I guess what I'm wondering from your perspective, because I take your argument about the hypothetical versus actual evidence, right? There was no evidence presented on any of that. Is that your just the hypothetical? Like was there any evidence confirming all the guys on day shift were senior to your client?
No, and that's our point.
Okay. All right, and there was no evidence presented on the issue of sort of taking somebody from, day shift to cover the night shift. That would have been necessary. There's no evidence of that. Just sort of the naked assertion.
Right. So I don't know if I'm answering your question correctly, but I guess what I'll say is there was no evidence in the record whatsoever of what the staffing was for those shifts. And I suppose there could be any number of reasons why somebody might prefer night shift to day shift. And what the investigator's report rests on, and what the commission is asked to decide, is to take the state's word for it that the only reason somebody would want day shift is because, or the only reason somebody would want night shift is because they're junior. I think that's too big of an assumption to make.
I've got it. Thank you.
Any other commissioner questions for Attorney Morris? Attorney Carter, 50 seconds left.
I'll just say that whether we consider it sort of an unreasonable assessment or an undue hardship assessment, we think we prevail either way, because clearly there is a violation of the seniority system here. Investigator O'Reilly discussed it under an administrative undue hardship. We're fine with that. We don't object to that. We think it's also an unreasonable standard. I will also just say this. Attorney Morris mentioned, there might be some people who are more senior who want night shift. And that's true. Some people might. They already have it because they're senior. So they got first dibs. They got first picks. So it's just because there might be some other reason someone might want night shift who is more senior, they have it. What I'm saying is there is not a way to move Mr. Williams up and effectively replace him without displacing someone more senior. If there was anyone on day shift who was more junior than he, they wouldn't have that shift. He'd have gotten it in front of them. So there was no way to replace him on night shift. And Attorney Morris has mentioned a hypothetical. That wasn't a hypothetical. That wasn't hypothetical evidence. That was argument. I was using a hypothetical to illustrate the argument, and I believe the investigator agreed with that argument. Ultimately, I believe Investigator O'Reilly adopted it. It's not evidence in itself. It's explanation, as I just did. The evidence is that of the day shift spots available, or of those who held the day shift, we asserted that they were all more senior than he was, and they had all won it through a fair bidding process. As far as I am aware, Mr. Williams does not contest that. So that's the evidence.
And that evidence is in the record?
It's in our submission, yes.
Yeah, okay, thank you.
The lack of contestation would be as well, yes.
Yeah, so you understand it as commissioners, we don't get the entire file,
yes,
right? So
yes.
what, to Attorney Morris's point, what is the evidence that you submitted, other than this argument that you just described, demonstrating that, for example, everybody who has day shift is senior to the client?
Well, the evidence would have been a discussion of the, let's try to pull it back up here in my initial submission. It would have been the bidding system itself that our witness who assisted us with this, who helped me prepare the answers, I submitted his name as part of it, explained that that bidding process happened for Troop G as it does with all troops, and the day shifts went first, well before Mr. Williams' name was even called. So that was the evidence. I don't know as we submitted anything. I mean, I don't know how regimented the sort of draft of shifts is.
Let me ask it a little more directly. Is there a statement from somebody other than you, right, sort of setting forth this scheme, the seniority and all of this?
Other than my client?
Other than you. Like you prepare a submission, right? You send it to the Human Rights Committee.
Yeah, yeah.
Are there, in terms of evidence in this case, are there statements from other folks? Are there affidavits from other folks?
We didn't get to that point in the investigation, but the information I provided is on behalf of my client, which is the state police, who gave me the information. And that was, I believe, what Investigator O'Reilly found sufficient was the, again, we provided the names of who provided us that information. Again, Mr. Williams doesn't dispute it, that everyone on day shift was more senior than he was.
Okay. All right, thank you.
Any other commissioner questions for Attorney Carter? Great. Thank you both.
Thank you.
Next, we'll hear from Jane O'Reilly, investigator assigned to this.
South Jane.
I'm ready.
Help us out.
I'm ready for it. Okay, actually, maybe not. Well, the record is going to fall off. Okay, I'm going to try to hold on to the papers here. So I'm going to start with arguments first and then go to the evidence part of it. The way the arguments were presented to me, very similar, if not exact, to the way that counsel has presented them this afternoon. So complainant's argument was that he made this request to transfer to day shift because there were vacant shifts. That was reasonable, and he could be moved into one of those shifts. And they just denied that out of hand and didn't provide him with enough evidence as to why they couldn't do that. Respondent's argument being, yes, we always have vacant shifts, but we assign based on need. And if we don't have all of our shifts, all of our positions filled, then we must put people in shifts where they need to go. And based on the bidding system, more senior employees had filled the day shifts before complainant bid for his position, so he had to take a night shift. There is evidence in the record of someone other than respondent's attorney making that statement. So as part of the reasonable accommodation process, complainant was in contact with people at the Bureau of Human Resources who reached out to his supervisors and said, this is the accommodation he's requesting, this is the standard process. This is the accommodation he's requesting, is that feasible? Their response was that basically it's an essential job function to be able to work your scheduled shifts. The trooper he is assigned worked 12-hour shifts and bid annually based on their seniority. He's on the night shift and moving to the day shifts to make a short staff on the night shift and overstaffed on the day shift. So they got that information directly from the supervisor who would have been responsible for that staffing and gave that information to HR to then relate it back to complainant. There's also the evidence that's being put forth by complainant with regard to vacancies is basically a list of all the people who are assigned as troopers in Troop G. So it's not a seniority list, and it's also not a schedule, but it's a list of all the positions broken into sections that say who all the troopers are, and which section they're assigned to. And it's basically even groups. It's like 5, 6, 6, 7 in groupings. No one pointed out to me, complainant having that evidence and saying, look, there are open positions, to me supported what respondent was saying, that there are open positions, but they're trying to staff equally across whatever the shifts they have available are.
With the people that they have.
With the people that they have, exactly. So again, they want, they have, and you can look at it, if the seniority part of it is making it confusing, which often cases that involve unions do, because you overlap these two sort of systems and rules. Think of it as any type of business that has, hospitals, right? Hospitals have to staff shifts based on the staff they have. So you have nurses. who may or may not want, have shifts they want, that request would have to be analyzed individually. And if an argument made by an employer said, we have no way of transferring this person to this because of operational needs. Again, it's an individualized analysis, so it might not be in that situation if that's true. But here there was an argument made that there was because those shifts were bid for and filled and they had to then start staffing the night shifts, there was no ability to just move him without displacing somebody else. And I found that to be an undue burden on their operations to have them have to displace somebody in order to move him into that position. I did have a few more notes, but I think I'll if you have any other questions about how I did the reasoning on this.
That's very helpful.
Okay.
Any other commissioner questions for Jane? Thank you. Heard from the parties and the investigator. We're looking for a motion. There is one proposed finding.
Make a motion. I move we find there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of disability.
Is that? So.
Moved and seconded. Any discussion?
I think it's open and shut. It seems clear to me that there was not, they'd have to violate the seniority system, and unless council tells me that that's not the equivalent of, that's not a sufficient legal standard, then I think it's clear. Otherwise, the argument proves too much. Why wouldn't they give them the day shift if they didn't have to violate somebody else's seniority?
Discussion? All right, seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
So the findings are no reasonable grounds. We thank everyone for their participation, and the commission will send a letter to the parties confirming the results of the hearing. A little brief while I hand out lunch to the commissioners, and then we'll call the next case.
Well, you're not going to give me any lunch. I object.
What do you get for being out
You're by the ocean.
That's something. Yes, you're coming to the ocean.
There you go. Yeah, that's good.
I'm just gonna wrap it back.
And we have an extra rat.
You wanna come back?
Yeah. Mail it to me. Mail it to me.
I think you'll probably hear it.
Okay.
I actually don't.
So we start to hear argument? No?
Just, we're almost ready, Ed. One more minute.
I'll be right.
Okay, I think we're ready, Ed.
Next case is E24-0225, Matthew Melanson versus Crisis Counseling. The recommendations for finding of no reasonable grounds, we'll hear from first an argument from complainant.
And as we, one minute, Mr. Melanson, as we have hit sort of the halfway point, I'm just going to remind everybody again, please don't use the names of anyone who is not a named party in the complaint. So you can use the names of the parties, but please don't use the names of other individuals. They have been given pseudonyms in the report, as have other entities. Please use those pseudonyms, so supervisor, manager, or whatever. And I will remind anyone if you need reminding. Okay, so you have 10 minutes, Mr. Melanson, and as we've been doing, you have the opportunity to reserve some of your time to respond to respondent after they make their presentation, if you would like. Tell me how much you would like to reserve.
Yes, I'd like to reserve possibly about 3 minutes.
Okay, I'll start you off with 7.
Okay. My name is Matthew Melanson. I am the IT director, or I was the IT director of Crisis and Counseling. That wasn't my only job functioning. I was a SQL report writer. I was the HIPAA security officer, and I also did any other miscellaneous tasks that were needed to be done, that wasn't part of my job description. And what I am complaining about what happened on the 26th of April in the afternoon. I got a call from one of the individuals in question. She called me and she told me that she was done. She was terminated, and for me to do whatever I needed to do for her account in order to disable it. So, did I lose my... Yeah, okay. So at that point, I was waiting for the supervisor because our policy, our IT policy states that any termination has to come directly from the supervisor of the individual in question who is being terminated. It was being terminated. So I was waiting for the supervisor to call me. This policy of having individuals have their supervisors let me know, that was in place. That we put that in place 10 years ago because we went to the EHR, electronic health record, and it was very important that records that people who are had access to medical health records be disabled immediately, especially if they had high access levels to these health records. Are we, hopefully we're not having technical difficulties, but anyway, so I waited to hear from the supervisor or the immediate supervisor or the CEO or senior management, which I am a member of senior management, and I never heard anything about this. So I thought that this person was pulling my leg, that she was making this up, and I had no way of knowing that. And Monday came around, I walked into the building, I walked to the front desk where this person works, and there was nobody sitting at her desk. So I asked around, I asked the individuals all in the area, I asked the people she worked with, her coworkers, and none of them said they had any clue. And for me to get a hold of Tim, who was a CFO at the time, and
Mr.
Amber.
Melanson? Mr.
Yes,
Melanson, please don't
they
use
are
their names.
mentioned in the report.
They're not by their names.
Yes, Tim and Amber are mentioned in the report
You're
by their
mentioning
name.
your submission of disagreement. You may not use their
I will
name.
disagree with you. I will bring up the page number, exact page number that Tim and Amber are mentioned in the report.
Stop
Because I
using
know
their
I'm. Oh, anyway, they did not notify me. So I asked a special meeting with the CFOs, the co-CFOs of the agency. And the co-CFOs at the agency at the time were Tim and Amber.
Mr. Melanson, if you continue to use their names, I will mute you and you will not be able to participate further.
Okay. All right. I will not mention their names. All right. Anyway, they continued. I went on with the meeting and I asked them, why wasn't I informed? That's the only reason I held the meeting. I specifically held the meeting for Wednesday morning, April, and on May 1st. I specifically held that meeting, and the reason I held that meeting is because I wanted to know why such actions were taken. A clear HIPAA violation of the agency, and they had no answer. They could not answer the question. All they did was kept giving me a runaround and saying, we gave you a notice today, this morning. Well, this morning, May 1st, was 4 days later. And I had 4 days I was worried about the safety of our agency's EHR, electronic health record. That is unacceptable. That is unacceptable for me. That's unacceptable for any agency to allow high level. These people had high level access to electronic health records, to clients' personal information, their home addresses, their treatment plans, all of this information these people had access to, and they were giving them clear access to that information, regardless of whether they were let go or not. And they were not letting me know, the IT director, know that these people were let go, which is a clear violation. And then so I was upset. I went on with the meeting for about 10 minutes. I was upset not getting an answer from him. I said, I'm done with this meeting. I got up, I left, I came back, and they said that I resigned. And they walked me out of the building. They came into the building with another clinician and told me to step away from the computer and to walk out of the building. I walked out of the building and I sat there and I was crying. I was in tears. I was broken up and I didn't know what to do. So I drove around. Yes, I did park in the parking lot because I was so hurt and distraught. I didn't know what to do at that point. I was contemplating all kinds of stupid stuff, and I didn't do any
You know
of it.
that is 7 minutes. I will keep the timer running.
Right. All right. Whatever. Whatever. I'm done with it. Bye.
Commissioner, questions for Mr. Melanson? Right. Seeing none, Mr. Melanson, you have about 2 minutes and 45 seconds left when we come back to you. Attorney Alvarez, do you want to save any of your time?
I'll save whatever's remaining. Thank you. Okay. Good afternoon, Commissioners. Tani Alvarez on behalf of Crisis and Counseling Center, Inc. We disagree with much of the statements that petitioner set forth during the course of his brief statement. We do, however, believe that the investigator in this matter got got the findings correct and got the facts correct. Mr. Melanson did not request a meeting with the co-executive directors. He sent an email to the co-executive directors upon them sending an email out to the whole staff explaining that there were 2 long-term members of the team who were not being offered additional jobs as a result of redistribution of work and changes more generally within the organization. That notice itself noted that those individuals would continue to be considered employees until the end of the month, but that their last day of active work would be that day on May 1st, the day in which the complainant received information concerning this matter. More generally, I'll stop there. You know, the investigator's report does a very good job of laying out the facts. The behavior that occurred after Mr. Melanson said, "I'm done," and walked out of the room, that occurring only a few months after he had told senior leaders within the organization that he had active applications to other jobs and was unhappy in his position. And I'll additionally highlight from the investigator's report the fact that when we did give notice to other employees that Mr. Melanson had resigned from his position and walked out, that other individuals indicated that that was unsurprising based off of his behavior prior to entering the meeting. I'm happy to answer any questions that any commissioners may have about the matter. Thank you.
Any commissioner questions for Attorney Alvarez? And you have about 8 minutes left when we come back to you.
Thank you.
Mr. Melanson, you have 2 minutes and 43 seconds if there's anything you'd like to add.
Okay. Yeah, I have a lot to add. Mostly that is all lies, actually. Not mostly lies, but all lies. I am been in nothing but, you can look, I haven't actually included my HR record. Spotless. I've never had any complaints against me. All of the workers liked me there. This is an open and shut case. They were in the wrong. They clearly let these accounts go for 4 days. 4 days. I had worried about these accounts. I come in each and every day and I said, "What's going on with these days?" I actually went to the CFOs. I went to the CFO's door and I knocked and he wouldn't answer. And I went to the other CFO, the female CFO, and she wouldn't answer either. None of them would. They would take my questions. And yeah, they released a letter on May 1st. May 1st, they released a letter. 4 days later, after the IT department is concerned about these accounts, about any nefarious activities that could have happened because of these accounts being let wide open. They are shared. Front desk usernames and passwords were shared among all the users for ease of use. And this was being used. This account was being used and it was being jeopardized. And I was trying to bring that to their attention. And that's the only thing I was trying to do. That's my time.
Commissioner questions for Mr. Melanson? Being none, we will return to Attorney Alvarez. You have 7 minutes and 56 seconds if there's anything you'd like to add.
We don't have anything to add. We rely upon our previous submissions and the investigator's finding. But if any commissioners have questions, we are happy to answer those questions.
Commissioner questions for Attorney Alvarez?
Thank you.
Thank you both. Next, we will hear from Jana Whalen.
Good afternoon, commissioners. I don't really have anything to add. Again, this case was determined based on I didn't see any causal connection between complainant's report and the adverse action he had suffered. I'm happy to answer any questions.
Commissioner questions for the investigator? Thank you, Jane. So we have heard from the parties and the investigator. At this time, we are looking for a motion. There is one proposed finding.
All right. We'll move, there are no reasonable grounds to believe that. Wait a minute. Named the wrong one. Wait a minute, Lindsay. Okay. There are no reasonable grounds to believe that Crisis and Counseling Center retaliated against Matthew Melanson for engaging in WPA protected activity, and the complaint should be dismissed in accordance with 5 MHRC subsection 46122.
Second.
Moved and seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Nicholas?
Yes.
Thank you for taking your time.
Commissioner Walker?
For 2 other angles.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable grounds. The commission will send a letter to the parties confirming the results of the hearing.
There's other ways.
Next case is E24-0228, Lindsay Matthews versus Complete Labor Staffing. The recommendation is for a finding of no reasonable grounds. We'll hear from complainant.
Jason, do you want to reserve any of your time?
Okay, we'll 2 minutes.
Tim and Amber. Tim and Amber is their name. Tim and Amber.
Yeah.
Everybody need to take a beat.
Right.
Okay. New case.
So, good afternoon. I'm here requesting that the commission does not adopt the investigator's report and either find reasonable grounds or remand the decision for further investigation. We filed a charge in June of 2024, and the gist of it, at least on the main side of it, we filed it also in New Hampshire, where they have found reason or probable cause of a hostile work environment, but I don't think that really relates here. I don't think there's an argument that she didn't report in good faith. Alleging that after she reported her supervisor in New Hampshire of sexual harassment that she was retaliated against, including when she asked to be transferred to their Bangor office to care for her mother, that she was not transferred. To be clear in the charge, we alleged it generally that she asked for a transfer to be hired into the Bangor office and that they did not do so. We cited a branch manager opening as one specific example of their failure to bring her to the Bangor office. And so that was in 2024. In the spring of 2025, a former branch manager of the Bangor office, him and Miss Matthews weren't like friends or colleagues, they knew of each other, but he got her contact information from a former employee, and he reached out to her and indicated that he had information relevant to her efforts to transfer to Bangor. So we contacted this witness, and he explained that he had been essentially that after Miss Matthews applied for the branch manager position, and he said she did apply because it was posted, that the owner and the district manager took down that job posting, and that they essentially put him in the position without even applying, and that he filled that position. And then one of his responsibilities after he filled the position was to fill his old position because he used to be a CSR in that office. But they told him under no circumstances are you to hire Lindsay Matthews. And the reason is because she has a charge pending against us, and that she accused her supervisor in New Hampshire of sexual harassment. Well, this is information he's telling us. And he said there was another position that they had to fill, and it was the same thing. Like, you can't hire her. He said there was another employee that they told him not to hire, but we didn't get into the details about that. So it immediately struck me as very credible because there'd be no reason for him to know about the charge or know about the allegations of sexual harassment. It was a confidential charge pending at the Human Rights Commission. So the only way he could know about these things is, as he said, from the owner and from the district manager of the company. So he came to us, he disclosed this information, we found it credible. We got an affidavit from him and we submitted that, so we have sworn testimony. And so I would characterize this as probably the best evidence of retaliation that you can have in a case. It's not something that you usually see, a manager who's honestly indicating that he was directed to retaliate and that he then did retaliate. And so in that context, we were disappointed with the no reasonable grounds finding. And for the obvious reason, I think that we have this very strong evidence of retaliation, direct evidence, and that it was just thrown out essentially in its entirety. Even though the witness wasn't interviewed, there was no INR conference, there was no steps to corroborate what he said. And I think that's really important. In the report, it talks about that Miss Matthews had essentially done something wrong by not showing job postings to positions she wasn't hired for. But as this witness pointed out, they didn't post them, or if they did it in a confidential manner, so she wouldn't even know. And I think that that's unfair because the respondent has the information, they have the documentation. The commission could find out from them, say, we want all the documentation of the job posting for the branch manager. We want the documentation that shows whether or not Ms. Matthews applied. We want the information showing that you hired this other guy as the branch manager. We want the information showing how you typically post CSR positions and how you posted these positions, if you posted them at all, and who you hired for those positions and what their qualifications were. Ms. Matthews had done the CSR position for years and she did it well. So on some level, even if the investigation doesn't accept his testimony, just based on credibility, there's ways in which it could be tested and corroborated, and we expect that it would. And that, again, that documentation is in the possession of the respondent. They did in the affidavit from the owner in their closing letter indicated, actually, yeah, they did hire someone to fill this branch manager's position when he was promoted, but that's all they say. We don't know anything about her qualifications. We don't know anything about the process. So we believe that the investigation was incomplete. We also believe, where the standard is an even chance, that here's someone under oath who's saying these things. It's not in his interest. He's essentially acknowledging he played a part in retaliation, that a reasonable fact finder could conclude that his testimony is credible, and that if an investigation is going to completely discount a sworn testimony from a witness, that it should at least be based on actually talking to him, asking follow-up questions, testing his testimony. And so for those reasons, we believe that the investigation got it wrong. I'm going to leave it there for now and happy to answer questions.
Questions for Attorney Hudson?
I mean, it's not really in dispute that this guy lied about why he left the company, right? This witness.
I mean, I wouldn't say it's a little messy, right? I mean, he says that when he was let go, he was told he's an at-will employee, and then subsequently he's having conversations about it. But yeah, I'm not going to say like, oh, there's an easy explanation. But the point is, no one ever asked him about that. Right? The point is, no one ever asked, like, well, why would you say that if this is the case? And then it can be more nuanced.
No, I understand your point.
Yeah, but what
I'm saying is that, you know, some people might say in response to what you just said that there was no reason to ask him because we have the text messages and we know what he said before. He was just, you know, he wasn't given a reason. And then we have these texts. I made an error in judgment. I love the company. Zero intention of stealing anything, right? I mean, I think that's pretty clear. Yeah,
and I think that's a point. And I think when we're weighing the standard, right, and we're looking at it from whether it's a judge, a jury, that someone could say, I find that because of that, I'm going to throw everything out. Like, he's now ceased to be credible on any front. But here's something that's ancillary, and in retrospect, I don't even know why that's in the affidavit, and probably next time wouldn't put in anything about how their employment ended, just because it can't be what I would consider like a collateral attack. But at the end of the day, he raises a lot of questions, right? And the fact that, I mean, you could also say that the owner and the district manager, like, they have their biases, and like, can they be believed? Because initially it seemed like they're saying, oh no, we didn't have any positions. Now they're acknowledging, oh, actually we do have a position that we filled. And I think also it's worth noting that what this gentleman said is that the owner and the district manager were the ones directing him to engage in retaliation. The district manager doesn't work there anymore. There was no affidavit provided by him. So essentially that's unrebutted testimony. And where he doesn't work there anymore, I think it's quite possible that he would corroborate it himself. Again, the respondent could argue, well, it's just another disgruntled former employee. But the point is no one ever talked to him. So essentially, this guy's testimony is being thrown out, even though there's no testimony from the district manager to contradict what he said about what they discussed. So I just feel like at the end of the day, sure, in the context of assessing this in the equal chances analysis, some fact finders could say, I don't trust anything this guy says ever. There's other fact finders who could reasonably conclude, like, it may impact it, but I think that it's credible, and there's things that make the respondent's position not credible. But I think most importantly, there's ways that it can be tested and vetted. We can find this out, and unfortunately, the respondent has all the documentation and information. And we're in the position of kind of sitting there wanting and hoping to get that information so we can get answers that don't depend on this witness's testimony necessarily. They will be corroborated by the documents.
Any other commissioner questions for Attorney Hanson? And you'll have about 4 minutes left when we come back. You are not Attorney Ford?
Attorney Ashley Theodore. I do have an appearance in the case. I'm not quite sure why I didn't come up, but I am representing the respondent today.
Great. Do you want to reserve any of your 10 minutes?
Sure. I'll reserve what I don't use, and I don't expect to go more than 5 minutes.
Okay. Whenever you're ready, go ahead.
Very good, thank you. I'd like to first just mention that while there was a probable cause finding in New Hampshire for the hostile work environment, there was a no probable cause finding for retaliation, just so there's the all of that information for the commission. But I'd like to start with that the investigator's report considered all of the evidence and came to the right conclusion there. Essentially, she found that there was no evidence of any type of retaliation. And first is that the complete staffing and labor considered all of the applicants for the branch manager, and the one of the current employees at the time listed as employee, I think, in the investigation report, indicated to the vice president that he was interested in the position on March 11th. So this is far before the position was even available or posted. So the company reviewed all of the candidates and found that the employee who was taking on the responsibility of that role was the most qualified for that position and did get the position. In addition to that, they interviewed the other employee at the location as well, who also said that he should get the position. So that's why he received the position. The majority of the issue that the complainant has is that this affidavit was not considered. And unfortunately, this affidavit is not credible. And I think the investigator was correct in her assessment. This person said he was not told why he was terminated. However, the same day he was terminated, he was texting the vice president about stealing from the company. So obviously, he had some knowledge as to why he was terminated, not to mention it is in his personnel file, which was provided to him as well. In addition to that, there's a bunch of things in his affidavit that are not credible and make no sense, even if, you know, as you do what Attorney Hanson is arguing and take, you know, that maybe he could be honest in some of his statements. Number one, he talks about that he had no knowledge about the branch manager position and the hiring for that. So I'm not sure how he can speak to this at all, but he says that they took down the branch manager position once complainant applied for the position. I'm not sure how he has any knowledge of that. It's not clear to me. And it also doesn't really help the argument that it was taken down once she applied because she already applied. So I'm not sure how that matters. He also says that he was instructed not to consider the complainant due to a lawsuit for another CSR position. But I'm not sure how he is aware because she didn't apply for the position at all. So that statement is also undermined by that. And I think I heard correctly that he really didn't know who the complainant was at the time he was working there. They had no interaction. That was what I think I heard Attorney Hansen say, but I could be incorrect. Lastly, he says things about how the CSR posting was posted confidentially. The vice president's affidavit explains that you get better candidates because a lot of people don't want to work for a labor and staffing type firm. But that did not stop the complainant from applying. The position was still available for her to apply to, and she didn't apply. So generally, his affidavit is not credible. The things he says in there are not credible. And I think the investigator was correct in completely disregarding that and taking the words of what the vice president said in his affidavit. I don't think there's any additional need for the investigator or anyone else to consider the affidavit of somebody who was completely not telling the truth. Thank you. That's all I have, and I'm happy to take questions.
Questions for Attorney Theodore? Seeing none, you'll have about 6 minutes left. Attorney Hansen, you have 4 minutes and 7 seconds if there's anything you'd like to add.
To touch on a few things. I think it still begs the question, and I think as counsel pointed out, how does he know about her charge? And how does he know about her allegation of sexual harassment? Which is something that was between her supervisor, the management of the company, and the Human Rights Commission. And so I found that when he contacted us it gave him a lot of credibility in my eyes. It's like, how does he even know this? And so I think that's still, in terms of what a reasonable person or how they could weigh this, would say, this guy might be telling the truth. We need to dig further. And absolutely looking into the documentation, what we're saying is that Lindsay Matthews did apply for the open position. And then after she applied, they panicked because, as she says in her affidavit, she was telling them, I need to transfer to take care of my mom. They know she wants the job. They get her application. They know she's qualified. So they just pull it down. And then this could be verified too. This guy never even applied for it. They just gave him the job. And so they're making it out like it was this balance, like we considered who would be the most qualified. One of the arguments at times is that she didn't have a vehicle, but as she's made clear, she would have a vehicle in Bangor, and she told them as much. So that undercuts that as well. So I think under those circumstances, and then the respondent keeps saying, well, she should have applied for the position that they weren't posting. Like she doesn't, if you look on their website, that's how they usually post them. They are right now, CSR position, branch manager position, but they were intentionally not doing that. And so she didn't see it. She didn't apply to a position she didn't know existed. But again, by digging into that and by looking at what was posted, if it was posted and why and who applied, we could get to a place where these allegations would be corroborated and it wouldn't just be based on his credibility. So I feel like this investigation is just really just half done. But if we have to base it on what's in the record, a reasonable fact finder could absolutely credit what he's saying based on all these reasons and find that there was retaliation.
Questions for me?
I guess one of the things that I've been thinking about is, I understand your characterization of the issue with the employee, right, as a collateral issue. What I'm wondering though, and I'm curious about how you are thinking about this as well, the reason why he was terminated, right, from his job was related to an allegation of theft, right? And typically he acknowledges, yes, in fact, I did it. Isn't that a kind of allegation, right? It gets at truthfulness, right? So in that way, it's not a collateral issue. Couldn't we think about the reason for his termination at core as being a reflection on his core tendency or propensity for truthfulness?
I think from like a rules of evidence perspective, no, I don't think that would come in. If you had a conviction for something relating to truthfulness, My understanding of the petty cash issue wasn't that he was like putting it in his own pocket. It was that he was using it to pay employee expenses in a way that was contrary. And I don't really have a good sense of this because it's just something that kind of popped up after the investigation had closed and we didn't have a chance to.
Is it in the record then? Is it in the record?
The issue about, well, yeah, it's in the back and forth in the text and things. So what I'm reading is that it has to do with like, you were using the petty cash to pay employee expenses. That's what I read in there. And so that's my understanding is it's more about a process thing, not like he's stealing the petty cash. But again, I only have very limited information about that. But I understand what you're saying. Like this goes beyond just that he wasn't fully truthful about why he got let go. This might go to whether, you know, if someone who steals money might be someone who can be less trusted. I think for those reasons, because the federal rules wouldn't allow that evidence in as evidence, and because I don't understand it to be theft, I would say not as much. But yeah, I think it just comes back to it's all on paper. And I think that's the importance of when we're assessing credibility, like we are right now, and you're in a room with somebody, or at least you're on a Zoom with somebody, and you ask follow-up questions, and you really get to the bottom of it. You test things like, as counsel's saying, well, what about this? What about this? Like, is this, I mean, I find it credible, but the way to address it would be to actually talk with the person, potentially let other people ask questions. And that wasn't done. So all we have is on paper, someone saying, indicating he knows things that the only way you could know them is if he's being truthful, and acknowledging that he was a part of retaliation. And I think that in itself is strong enough to make this a reasonable grounds case. And then if it goes into litigation, wherever it goes, these things will be tested. Like he will be deposed, and we will subpoena the documents from the company and see the extent to which they corroborate what he was saying. But at this point, this is what we have.
Questions? Attorney Theodore, you have 5 minutes and 57 seconds if there's anything you'd like to add.
Sure, just a few things. The first is that the employee expressed interest in the manager role on March 11th. So while there may not have been a formal application process, he did say, I would like this position. So it was known to the company that he wanted it. Number two, just to clarify about the CSR position that was posted, it was publicly posted, and complainant could have seen it had she gone on the computer. The only thing that wasn't there was the name of the company, which is something the company does all of the time. It was explained in the affidavit of the vice president, and it's to get more qualified candidates. Again, it's because a lot of times candidates don't want to apply to a staffing firm, so they make sure to get rid of the name so they can get these qualified candidates that they normally wouldn't have had. And complainant could have applied to that job posting. It was publicly available. Let's see. There's one more point I wanted to make that just slipped my mind for a quick second. I just wanted to make a point about the jump that's being made by complainant about that the employee had knowledge about this complaint. We don't know. This was filed to the commission during the time he was still employed there. He was the manager of that location. It wouldn't be unreasonable during the litigation process for the manager of the location to be aware of something like this. Thank you.
Commissioner, questions for Attorney Theodore? Okay. Heard from the parties, and next we'll hear from Jane O'Reilly.
Good afternoon, commissioners. I'm just going to lay out a little bit more about the timeline of this case in terms of my investigation. I do think it matters, given the discussion of how this evidence came in and why it wasn't followed up on, all these things. The first thing, though, I want to mention is, and it took me a while to find the submission in the record. It is not in the record what complainant's attorney has stated today, how this individual got in contact with complainant. So the context of out of the blue, he found her, he said, I know all these things, and then they got the information from him. The email says, here's complainant's response, and it details the information in the affidavit, but that specific context of what he's saying is established in his mind for credibility today, that how would he have known these things? Now, that wasn't argued to me as part of why this affidavit was credible. It also was received, so this complaint was filed in June of 2024, 2026, that wrong. Was filed in June of 2024. I closed the record, I sent a notice to the parties that the record was being closed on January 28th of 2026. It was received on the final day of the close of evidence submissions, this affidavit was. So I received it as a final submission at a point at which I normally, the record would be closed, there would be no opportunity to respond. And I reopened the record to give respondent a chance to respond to that information because of course it was valuable information that hadn't been available before. I didn't know, where the witness had come from or what the information was. So I gave respondent a chance to respond and asked a few additional questions of complainant for that purpose. But given the stage of the investigation at that point, and the fact that nothing about this witness had been mentioned previously, or there was no indication of anyone else that was going to be able to provide information, I limited it to that. And as I mentioned in my report on the final stage of analysis, I had affidavit versus affidavit. I had an affidavit that was credible and an affidavit to me that was not. Whether, again, I have to look at the evidence based on the standard of would this succeed in court? And as has been discussed, yes, any individual could see truth in part, even if there's falsity in part. But I have to look at what I have when I write the report. And at that stage, he specifically stated in the affidavit, I was fired at will. I was given no other reason. And it's very clear that he knew there was another reason he was being terminated, whether it was through the, termination notice they gave him or the text message he sent to a supervisor saying, I know this is, bad behavior, please give me. I'm happy to answer any questions.
That's very helpful.
Okay.
Thank you for that clarification about the timeline. I'm curious too, when I read the report, very helpful. I read Attorney Hansen's objection for rebuttal, and I thought it was very good, right? I thought it was very persuasive with respect to shouldn't we be treating this case, right, where a complainant satisfies the at least even chance standard. I'm curious about when you read Attorney Hansen's rebuttal here, what did you make of it? I don't mean to suggest I want you to go through point by point, but give me your response and reflections on now having an opportunity to hear a fulsome argument from Attorney Hansen about this affidavit.
Sure. So there are a couple of things that come up sometimes when you read a submission of disagreement, which is sometimes it focuses on an argument you didn't make in your report, right? So it focuses on certain aspects of the case that you didn't necessarily focus your investigation on. And that's in part because I'm trying to write my report to the most important issue, right? But what I can say about what's in the record up until that point as well, as Attorney Hansen and complainant is obviously focusing on the strongest evidence in the case. But to me, it's still part of a larger context of the entire case. And up until that point, there was almost no evidence that there was any kind of discriminatory animus. There was also no evidence really that she was reaching out to respondent post her move to Maine and getting rejected. I mean, again, this is all about supposition about, it's certainly evidence of animus by the employers being held, but it's not necessarily evidence of a respondent taking an adverse action against her. You still have to, show that you're applying for jobs that are you're being denied them. And like Respondents Council mentioned today, there's no evidence that she was trying to find jobs there and couldn't, right? They were hiding them from her. They say they were, but there's no evidence that she provided that she was searching for them, trying to get hired there and not able to apply. So that was part of my investigation as well. I had to focus on what actions she did take to try to get a job there, which was this branch manager position, and what actions respondent took, and what evidence I had of their reasoning for those actions. And based on the entirety of the record and the sort of last minute, not so reliable evidence that maybe they didn't like her so much because she was suing them. And the evidence, if true, yes, they were hiding posts from her and things like that. But again, I have to look at the whole context of the record, and it still didn't persuade me that she had provided sufficient evidence to support her claim in court, at least an even chance that she had sufficient to show that they were, she was prevented from getting a branch manager job or any other job in this location because of her productive activity. Anything else?
Question is for Jane.
Thank you.
We have heard from the parties and the investigator. At this time, we are looking for a motion, one proposed finding.
I mean, there are no reasonable grounds to believe that complete labor and staffing retaliated against Lindsay Matthews for engaging in WPA and or MHRA protected activity, and the complaint should be dismissed in accordance with 5 MRS section 4612.
Second.
Moved and seconded. Any discussion?
I just want to say, I don't believe there's an even chance. I appreciate the arguments. I think it's very skillfully argued, but I also think that employee, as referenced in this report, gets absolutely shredded at trial by any attorney in this room. So I think after that, it's, you know, I think it's a pretty tough case. So.
Or non-attorney.
Yeah, no disrespect.
You go.
I was just appreciating vote of confidence there, having not been in the courtroom for about 8 years. All right.
But I can't.
So the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Walker?
Yes.
Sanders? Yes. So the findings are no reasonable grounds. Commission will send a letter to the parties confirming the results of the hearing. Thank everyone for their participation. 2 more.
Next case, the penultimate case is E24-0230 Julie Gil Blair versus the Somerset County Jail. The recommendation is for a finding of reasonable grounds. Therefore, we would hear from respondent.
Good afternoon.
Attorney Chafee?
Okay.
Chafee. I was just 50 shot there. Do you want to?
It's better than most.
Do you want to reserve any sort?
Why don't,
Whenever you're ready.
thank you. Good afternoon, commissioners. Hello, Julie. Nice to see you. Jane, pleasure working with you again. As the commission has likely seen from the objection we filed, we feel very strongly that there should be a no reasonable grounds case. The allegation, of course, is that there was discrimination based on disability, and in particular that there was a refusal to provide a reasonable accommodation. And that's really going to be the focus of the thoughts that I share with you all. But a little bit of background here. The employee had a full 12 weeks of family medical leave that was approved, and that expired on February 22 of 2024. The day before the expiration, the employee asked for an extension and promised that she would return on March 2nd. The county commissioners took no action. They did not approve it. So the following day, leave was exhausted and had expired. There was no contact. I heard the term used before, no call, no show, for February 23rd, 24th, 25th, 26th, 27th, 28th, 24 was a leap year, 29th, March 1st, or March 2nd. No, hey, I'm not coming in, no nothing. So as you're all aware, under case law from this state, an employer is de facto within its rights to terminate the employment of an employee who fails to return to work after family medical leave expires. There's a fly in the ointment. The fly in the ointment is that on March 1st, not having shown, not having called for the 23rd, 24th through the 29th, And so it's certainly within that window being fair game for termination. On March 1st, the employee produced a doctor's note saying she needs to be out for 8 more weeks and can do seated work only. So if we are generous and charitable and treat that, even though it was not stated as such, as a request for reasonable accommodation, that then becomes the question. Now, I have to throw in here, the employee had made clear all along during her leave, she intended to retire in May of 2024. There are emails in the record where the employer is asking, is that your return date or your retirement date? For clarification, the answer is retirement. If anything changes, I'll let you know ASAP. And there was never any further communication on that score. So from the employer's perspective, February 22nd comes, they've given the full FMLA, and incidentally, they had done a prior FMLA. Never any problem, never any issue, never any question about should you get it or shouldn't you get it, granted routinely. The full 12 weeks is given, it's exhausted, no show, no call, no return, and then all of a sudden, the day before the employee had promised to return, even though that was a week after the exhaustion of the leave, here's this doctor's note saying I need 8 more weeks, which coincidentally gets us to May, and that's the retirement date. Does that really matter? I wouldn't hinge the case on this. Here's what I think really matters and where this clearly becomes a no reasonable grounds case. I've heard all day about even chance. So if we treat the doctor's note as a request for a reasonable accommodation, this is not an office job like I do, where I can do it sitting down. This is a corrections officer position. Can a corrections officer, can a so-called, and I hate this term because I work with these corrections officers and I feel like it's kind of disparaging to them, but can a jail guard do that job in a seated position only for 8 weeks? And the answer is no. First of all, if you look at the job description itself, in terms of what's required, among other things, to take emergency action when necessary by established emergency procedures and protocols, which require a high level, potentially, of physical activity to intervene in physical altercations with inmates, responding to all incidents of inmate behavior immediately, and to ensure the safety and staff of inmates by performing searches of inmates, rooms, and the entire facility to prevent the use of prohibited materials and seize contraband. You can't do those things sitting down. And this is not me, the lawyer, talking. This is the sheriff himself who answered a number of questions from Ms. O'Reilly, along with, I think it was the jail administrator, Mr. Pike. That's just the job description. Now, the response that we heard was, well, you've let other people just work in control when they were on light duty. Control's the room where you sit and it's got all the screens. And you do, potentially. You could be seated in there, except that, and this is in the record, in November of 2022, remember now, we're talking about March of 2024, a memo was issued from the sheriff to the folks in the jail saying, we can't do this anymore. It is a liability. It's a security threat. It's a security risk. And among other things, it said that by having officers only posted in control, and that is the only post in the jail where one can work from a seated position, this has become problematic when these officers call out or take time off. Many of our new officers have not been able to train in control. This affects not only operations, but the safety and security of the facility. Often the shift supervisor has to staff central control due to one of the light duty officers assigned to control calling out. If the shift supervisor is in central control, they cannot effectively respond or assist their officers on shift. It is imperative for the successful operations of the facility that all officers have the ability to work all posts. And then it goes on to say that if there are doctor's notes that folks at the jail would make every effort to provide reasonable accommodations so long as the essential functions of the job can be performed. And then to drive the nail home when asked in the interview with the investigator whether she would be able to perform her job functions seated. What she said was, the question was, do you believe there was an accommodation, a position at the jail that you could have performed entirely seated? Honestly, I was under a doctor's order for seat work, so I can't change that. I was under medical care for him, but I believe I could have sat in a seat in intake and helped answer the phone. I believe I could have sat at a post chair. I don't know if I walked. I couldn't run. And she went on to candidly acknowledge that even in control, occasionally you have to get up and assist. There are occasions, if you're the only female on shift, that would occur. So we're not talking about convenience of an office here. We're not talking about economics or profit. And really, money has nothing to do with this. That's typically what we see in these reasonable accommodations and undue burden cases. We're talking about safety and security of other officers, of inmates, of non-security staff, whether they're the medical staff in the jail. And these are not theory. We've heard about hypotheticals and theoreticals today. These are events that occur on a daily basis. And I am confident that the complainant will agree with that the job of being a correctional officer is a physically demanding job. It's a dangerous job. I give those folks a ton of credit who do it, and you cannot do it in a seated position. And so that was the doctor's requirement. 8 weeks, seated only, simply cannot reasonably accommodate the essential functions of the job from a seated position. And for those reasons, we feel strongly that there was no discrimination here. It's not an even money bet. There is simply no evidence that the employer could have provided any accommodations. It's not an even chance. It's 100 to nothing on this one. There's not a shred of evidence in the record that the employee could have done all of the things that a correctional officer has to do. That it is imperative that all officers have to have the ability to work all posts. So it's not even close to an even chance. And for that reason, I respectfully ask you folks to not endorse the recommended finding and to find that there is no reason.
Yeah, I'm curious. I'm going to follow up on that last post. Thank you.
Sure.
Very helpful. I think I heard you say that it's just the case, right? The fact is that officers have to work all posts, doing all job-related responsibilities. And if that's true, I'm curious, right, when somebody does come forward, they have a workplace injury, they need light duty, or an individual needs an accommodation, seemingly like the complainant did here, is the answer simply no, we can't accommodate you? In the case of light duty, they're out of work. In the case of accommodation, you claim undue burden, the person is terminated or transferred. How does that work?
That's a really good question. It's a fair question. And the answer is it's a lot harder to accommodate a corrections officer for light duty than, let's say, a lawyer.
Sure.
But it doesn't mean that it can't be done. It really depends on what is the accommodation that's needed. And where the accommodation is so extreme, as it is in this case, is you can only sit. You can't do anything else. You can't perform a strip search on an inmate where you may be the only female officer on staff, and we've got a female inmate who's coming in who has to be searched before they can be admitted to the population of the jail. So the answer to your question is it's a lot harder. It can be done. It's done on a case-by-case basis. It depends on what the accommodation is that is needed. But when it is as extreme as this, and as Ms. Jill Blair herself conceded, that she could only sit, it actually, in that case, is not possible.
I think I heard you read for us, which was, I guess, very helpful in response to the question about what the complainant believed she could do at the jail. She said, I can do intake, I can answer phones. Is that not the case? Did your client consider that as part of the request for accommodation?
The answer is, did they consider it? Yes, and it didn't take long to say that's not possible. What she said was, I could have sat in a seat in intake and helped answer the phone. Intake is the area of the jail. Actually, I was arrested many years ago before law school. I had a little personal experience there. The statute of limitations has long since expired. And I know from working with the correctional professionals, intake is a very busy place and it's a dangerous place. It's the transition zone from someone on the outside, maybe somebody's very cooperative and submissive, often not the case, to the secured portion of the jail, which is why the searches are so important. We don't know what people have on them. You cannot make up some of the things that people bring into jails or try to bring into jail. So intake is not a place where you sit. Now, do they have chairs for the officers? Yes, sometimes they're sitting behind the intake desks and things are quiet, it's nice, and then all of a sudden, Madison PD shows up with Pete Marchese, who's out of control, and it is transformed from a quiet operation to a very, very dangerous environment. And again, that's why I give the folks like Ms. Jill Blair a lot of credit for the work that they do. But all of that is a long-winded lawyer's way of saying, no, you really can't just sit there.
Yeah, Peter, what's the date of that memo that you?
The date of the memo is November 21, 2022. And if we treat that doctor's note as a request for reasonable accommodation, that was presented on March 1, 2024. So this was well-known and well-established long before this.
Right. So the investigator's report says that, the memo discontinuing this practice, right? The report says it's not done out of safety concerns. I'm just paraphrasing from the report, but because respondent believed that staff were not properly cross-trained and because it wanted to prevent burnout. And I just want to clarify, you feel that your memo sort of addresses all that. You don't need to say anything else.
And Jane's quite correct when she said that is part of it. So you have to, there are a number of different posts in the jail. And, it's, I'll use being a lawyer as an example. If I practice employment law, it doesn't mean I know anything about evictions from residential tenancies or something. So the corrections officers get trained in different posts as they come on board at the jail. And one of the problems, and this is the portion I think that the investigator looked at, one of the problems, was that if you had only so-called light duty officers working in control, you could never bring in these new officers and train them because the post was filled. And by the way, short staffing is a chronic problem in the jails. So you could never bring them in. Now, one of the light duty officers calls out, legitimate reason, can't come in today, I'm going to use a sick day, whatever. You don't have anybody trained to fill in control as kind of the nerve center of a jail. So now you take a supervisor off the floor and you put them there because they're trained in it. Well, now the supervisor's not on the floor, in the pods, in the intake area, in the special housing unit, in the maximum security area of the jail to be able to manage what's going on. That's problem one. But then the memo goes on to talk about safety and security of the facility, and how it is imperative that all officers have the ability to work all posts. So I think the investigator focused on one part of this, which frankly does dovetail into security. But the other part of it, and this was explained in more detail, of course, this is a memo, and when asked questions, the issue was thoroughly ventilated during the interview process. Both the sheriff and the jail administrator explained what I talked about earlier. If you're working in control and this is just an example, the only female, And this is something that the Ms. Jill Blair herself acknowledged in her interview. You may have to do things with other females. You're the only one on duty. There's only one female on duty. If you can't be relieved and controlled to walk down the hall and do a strip search or a pat search, which now you have to assume might become violent, because sometimes they do. If you're not able to do that, then the operation breaks down, and then it poses real security risks of contraband entering the jail, violent episodes occurring that can't be subdued appropriately. And again, if you, I always say you can't make up stuff that happens in the jails, and I've been doing it for, I hate to admit it, almost 37 years now, and I continue to be surprised. You can't be a corrections officer sitting down for an entire shift. You compromise, you put other people's health, safety, and lives at danger if you do that.
Right. So one more question. The complainant's desire to retire in May, right? So covered the communication between the respondent and complainant where she says, I'm going to retire, right? And the report details sort of a change of heart. I just want to be clear, that was never communicated to you?
No, absolutely not. And again, I would not come in here and hang my hat on. She said she was going to retire in May because, in fairness, she didn't say May 2nd. So if the request for reasonable accommodation, if we call the doctor's note from March 1, that 8 weeks gets you to from March 1 to May 1. She just said May. So we're not hanging our hat on. She was really just looking for an out here. It's just interesting that the last piece of the leave, the note was brought in 8 days after the other leave was exhausted, and it just coincidentally provided enough time to get to May. But, is that an even money shot? Absolutely. I'll grant you that. What I'm talking about here is you cannot reasonably accommodate that job. You can't perform the essential functions seated, and that's all she was able to do, and that's 100-0 in my book, and I hope so in yours.
Commissioner questions for Attorney Marchese? You hit your 10 minutes, right?
I heard it. I've never been accused of having an economy of words.
Ms. Gilbert or Gilbert? And you are muted. Ask you.
Still muted.
Yeah.
Muted.
Lillian, can you help providing the ask?
I just did.
Oh, sorry.
Okay, there we go. And since I'm mispronouncing everybody's last names today, are you Gilbert or Gilbert?
Yes, Julie Gilbert.
Okay. Ms. Gilbert, you have 10 minutes whenever you're ready.
Okay. I don't think it's going to take me a whole 10 minutes. I'm going to just review what I feel took place in regards to the 2022 memo. March 1st, it was communicated to staff in the jail that the central control seated position was being discontinued due to their list of hardships. So central control wasn't an option for light duty at that point. On December 4th through March of 2024, I was scheduled out on FMLA per my doctor. February of 2024, Somerset County notified me that my FMLA was over the allowed amount of days, the 12 weeks, that I needed to request an extension or risk losing my employment. So in February, I attended a commissioners meeting requesting the extension of FMLA, and they did approve me to return to work March 2nd. March 1st, I went to my pre-scheduled doctor's appointment it wasn't an appointment that I made up and wanted to go to. It was pre-scheduled by the surgeon as a follow-up. At that appointment, I was placed on seated accommodations for 8 weeks. And 8 weeks is actually 28 days of my jail schedule. So it's not, we don't work like a Monday through Friday job, 8 hours a day. We work 12-hour shifts. One week we'll work 3, the next 4. So we work 7 days in 2 weeks. Let's see. And on March 1st, I submitted my doctor's note immediately to communicate to the administration that accommodations was needed and I was now light duty. After submitting the doctor's note on March 1st, I waited for a response, for direction, for guidance on light duty or approval that I could return. I received no communication at all, March 1st. I was due to go in on shift March 2nd and 3rd, full duty. However, I was now light duty. So I did not go in as I had no direction or guidance. March 6th, 5 days later, administration finally contacted me to set up a meeting for March 7th. March 7th, I went to the meeting, and this is when I was terminated. And there was no discussion of any reasonable accommodations at all. I was simply terminated. I'm a 13-year correctional officer at Somerset County Jail, experienced senior staff. I maintain my employment by being a reasonable and ethical and productive worker. I had no issues in my personnel folder. On March 7th, I felt devalued and I was upset that after 13 years, I was terminated due to a physical condition. And that is why I filed a complaint. And do I have more time?
You have 5.5 minutes.
All right, I would like to say something at the end if I could, and I'll stop here.
You can, this is your chance to present. So if there's anything else.
All right, so I would like to end this with making a comment. We all can discuss discrimination all day, thinking we know all about it. But until you actually experience discrimination and feel how it can affect you, you do not know what it is. I felt on March 7th the effects of discrimination. And that's why I filed a complaint. The end. Thank you.
Commissioner O'Brien.
Good afternoon. Do you have issue? Do you disagree with the assessment that you could not be seated in the control room or there was no position for you for safety reasons? Do you disagree with that, or do you see that?
Well, I threw out some ideas on, because they took away the central control position, which was actually the safest. I came up with some ideas of seated work that may work, like the intake position, answering phones. I could sit in a pod and possibly with a new employee with my experience and train them in the pod. So yeah, I disagree. I feel that if they had wanted to and they wanted to work with me a little bit to accommodate, they could have. I feel they just don't want light duty in the jail. Where they used to, they're not anymore.
Follow up? Sure. And I think you did say that is a written policy. It's not, you just said that they used to, not anymore, and that's from a policy from, I think, 22, is that correct?
Yeah, they stopped it. They sent out a memo in November of 2022, and they stopped light duty in the safest position that could have been used for seated accommodation on, I believe it was in March of 2024. That's when it ended. So they changed the policy on that.
Okay, thank you.
Commissioner Douglas.
Yes, good afternoon. So I'm curious about your communications with the jail, the folks you used to work for, about your retirement. So you said that, well, according to the report in September of that previous year, there had been some exchange between you and the jail where you would basically let them know that you were planning on retiring. I guess there was some position where you got free room and board you were going to take, and then that fell through, and so you decided not to retire, right? And
yes.
I'm just wondering that when you changed your mind from that time through the time that you were terminated, did you ever let the jail know that you were planning to come back and work and not retire?
No, actually, I never had a discussion of any kind with the jail. I was terminated. They never asked. They never, no communication, which I thought was disrespectful. I've always been a good employee, and no, I did not. I did not turn in a 2-week notice or any type of notice saying I was ending my employment with them for retirement or any other reason. And that's usually normal, to give a written letter of some kind to let them know that you're ending or retiring.
Okay. But you did tell them at some point that you were going to retire.
I did send that email. Yes, I did, because I thought that I was, but technically I couldn't retire until May, because I would have been 62. I was only 61 at the time.
Gotcha.
I was terminated.
All right. And I just want to be clear about this. From the time you told them that you were going to retire to the time you were fired, you never told them that you were actually planning to come back to work.
No, because I was out on FMLA, and then when I returned, I was terminated.
Okay.
There was no time.
Yeah. All right. Thank you. Thank you.
You're welcome.
Commissioner David.
Ms. Gilbert, you just said that they changed the policy in 24, I think. They changed the policy to not be able to provide for light duty. Is that correct?
I believe the memo came out in 22. I thought it was 23, but.
But is your argument that they couldn't do that? That that's illegal in some way?
I really don't know the legalities of it. I'm not a lawyer, but it seemed a little off to have years of light duty for correctional officers. We're not robots, we're humans. We may fall ill, we may get injured. And now they took away the one safest position that an officer could use for an accommodation, and they took it away. They took that seat away. So
right. And I think that your case is asking us to find that they can't do that. They can't make that policy and apply it evenly to everyone.
Well, it doesn't seem reasonable to me. Now, the law, I don't know about it. If they legally can, they did, so they must be able to.
Okay, thank you.
You're welcome.
Any other commissioner questions for Ms. Gilbert? Okay. Seeing none, we've heard from the parties. Next, we'll hear from James.
Last one. Good afternoon, commissioners. You're almost done hearing the sound of my voice. Okay. Nope.
It's gonna happen.
And on the last one, I'm gonna drop everything. Okay, so So in this case, I want to start with where we just ended, with your question, Commissioner David, about what this case is arguing. Certainly from what I understood, that's not what the complainant was arguing. She was not saying that the policy itself of sort of, always just putting light duty people in the control room was discriminatory, but that because of past practice, that option could be used for her in a certain circumstance. So I actually also have the memo up, and at the very bottom it says, if a staff member has a doctor's note that requires them to be on light duty, we will assess that person's individual abilities to complete the tasks required in their job description as a corrections officer and make every effort to provide reasonable accommodations in accordance with the Americans with Disability Act and the Maine Human Rights Act. So the sort of shift in a prior practice was really about addressing this operational need, but still reminding employees that they had rights to request reasonable accommodations and they would still have to do an individualized assessment based on that request. So now I'm going to back up and talk about the sort of two parts of my analysis. So I think the respondent's presentation and then sort of by default complainants as well has focused on this issue of seated accommodations, the seated work request. That was only part of the analysis that I did with regards to this case. So the first step being, whether or not she could be accommodated with seated work. I found that there was not enough evidence in the record to support that she couldn't be, basically because even though they were making these arguments that all of these positions, were required to do all of these things, that in the past, there had been employees who had been able to be in control for the entire shift. The concern, the safety concern that was highlighted by a respondent's attorney was with regard to a supervisor having to cover, therefore the supervisor couldn't be available to help. But this was, the goal of this change was to make sure everybody knew how to do control. So if someone had to cover control who wasn't if someone has to be there, so why couldn't it be complainant who was there, freeing up a supervisor to otherwise attend, address a concern. There wasn't an additional safety concern about there being someone in control. Control is a position in the jail that somebody has to fill. But then beyond that, even if the arguments had been sustained that the seated accommodation would not work at all, there was zero discussion with complainant about any alternative. And there was zero argument provided by respondent why they couldn't accommodate something else up to and including additional extension of leave. So the argument's been made that she, because they had information that she intended to retire in Maine, that what she was asking for was just to be out of work forever. But that wasn't discussed with her at all. They didn't go back to her and say, give her an opportunity to provide any kind of alternative. When they sat her down to meet with her with regard to the end of her employment, she tried to say, is there anything else? And even when I interviewed her supervisor, who was sort of like, well, it was out of my hands. I was told by HR that she was out of leave. There was nothing else to do. The memo that I talked about in my report where they say what the recommendation is for ending her employment just says she's out of leave. She can't come back. She has nothing left. That's not an interactive process. That's not what's required by the Maine Human Rights Act. If someone proposes an accommodation and there's no discussion going back and forth, then that's another failure to accommodate. And then the final thing I'll just say is that the respondent made this argument throughout the investigation and also here today about her being the only female. I'm not sure, again, I didn't get into it in my report, but I'm not sure that you can use the fact that she was a female as a reason to not accommodate her disability. If you're understaffed and females in the jail, that's not related to her disability at all. It's not related to, again, maybe you only have a certain EMT on staff or something, the fact that she's, speaks more to the unavailability of certain staff in the prison than it does to whether or not she can be accommodated, and using the fact that she couldn't be in central control because she might have to leave as the only female on staff. I didn't really get to that argument as much, but since it was brought up so much today, I think I need to address it, that's not something that the Maine Human Rights Act would probably recognize as a reason to deny someone their accommodation. I'm happy to answer.
Commissioner Ryan.
Okay, that kind of I can't work that in yet because strip searches and all that. Everybody would have the rights, but the other thing that you said there was no discussion, and somewhere, I don't know complainant or respondent talked about talking that she could sit at intake, and then so there was some discussion.
That was a discussion between complainant and me.
Oh,
I asked her in her interview,
okay.
like, as part of the investigation, you know, if she didn't have anything to propose, that would have also sort of ended the interactive process too, right? Did she have any responses? And I do have the interviews up. I do think some of the statements were taken a little bit out of context. So, but I think complainant today gave more context to that statement. She did have lots of ideas. She also had ideas for, you know, stuff that maybe she could do. They could reduce her hours in control to 8 hours or 4 hours. You know, if she didn't, she wasn't sure what her doctor would release her to do. You know, at the time she couldn't run, but she didn't know, you know, she hadn't been able to have any of those discussions with her doctor about what could be accommodated because he said this, she said, great, I'll offer them that. Because if she could have had that, then great, she didn't have to ask any additional questions. Also the discussion that, you know, occurred between respondents, employees themselves, the supervisor, HR, who then ended up making the decision to end her employment. Again, when they said, you know, there's issues with her job description, she has to do these things with regard to safety. And when I pushed for more specifics, the same kind of things came out. She's the only female who can do, and I don't disagree with you that a female should do a search, but I don't think the fact that she's the only female on staff and she needs an accommodation means that she shouldn't get a similar accommodation that a male employee would get just because she's the only female on staff, right? That's something respondent has to address through its own obligations to provide females to do searches, not something that should impact her request. And then again, when I pushed them more and more on this memo, which respondent kept saying was about safety, it really was about operational needs. It was about cross-training. It wasn't about the fact that having someone in central control affected the safety of the operations of the facility. Somebody has to be there. So again, maybe it's true. The argument wasn't made to me and no evidence was provided to me as part of the investigation that was the case. I'm happy to answer my question. It's my last one, guys.
Any further commissioner questions for? Seeing none, thank you.
Thank you.
Heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding.
We accept the investigators' report as written. One, there are reasonable grounds to believe that Somerset County Jail discriminated against Jill Blair on the basis of disability and conciliation to be attempted in accordance with 5 MRS section 4612 subsection 3.
Second.
Moved and seconded. Any discussion? Commissioner.
I am persuaded by Attorney Marchese's argument. I think it's a close case. Jane concludes at the very end on page 8, the last sentence in paragraph 14, absent her disability, the need for accommodation, she would not have been discharged. That's absolutely true. Her disability was such that she could not be accommodated in that position, and that's his argument, that it was a safety concern. So I don't find the animus that it was discriminatory or illegal.
I agree with that. I agree with you for what it's worth.
Further discussion?
It is interesting. Because,
I'm watching your face.
Yeah, because I mean, yes, we did hear about the safety concerns from Attorney Marchese, but then we also heard from Jane that this memo was sort of a mixed bag, and it was, you know, cross training of supervisors, all this sort of thing. It really seemed to be as much the focus as we heard previously. So
yeah, it's a close case. I agree, but that's why we get the big bucks, Tom.
And to couple that, even if the conclusion was we're unable to accommodate the complainant, that could have been the correct conclusion.
Right.
what Jane laid out though, Investigator O'Reilly, in the report was that they didn't show their work to get there, right? They didn't engage in that interactive process with the complainant to understand, are there other things that we can do here that will allow her to perform the job? And it's really on that basis that I'm voting to affirm.
I understand, but they've been dealing with that situation for months with her. It's not all arising at the same time, and then they sort of know where they are by that point. Let's do it.
I think what Ed is saying is a series of leaves, right? Is that what you're
Yeah.
saying? There's like a series of accommodations that are happening.
Yes.
Yeah, it's a tough case. Yeah.
Maybe I know too much about jails.
Right.
And
Here we go.
yes,
Tell us about that, Julie.
and safety concerns and how violent it is and can be. So, and maybe that is what's tempering my thought process here, but that's what I'll tell you later.
For executive session.
Yes.
Any further discussion? Being none. The motion is to find reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
No.
Commissioner O'Brien?
No.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay, so the findings are reasonable grounds. The commission will send a letter to the parties confirming the results of the hearing and outlining the next steps. We thank you both for your participation and for hanging out with us all day.
You want to wrap?
Your reward for hanging out here, there are also pastries if you'd like something for the road. We have one more case.
Let's finish it up. E240244 is Stoltz versus Petco. I'm sure I didn't get the last name pronounced correctly. The recommendation is for a finding of no reasonable grounds, so we would hear the presentation from complainant.
Hi. It's
One moment, Ms. Dunst. Yes?
I don't think respondents here.
Oh, that's interesting.
Oh, Tom is recusing himself?
Is there anybody here for Petco? Angela, do you see anybody? Have you heard from anybody? Do not see anybody. There's nobody in the room.
Miss Angela, I just want to apologize for the 8 inches of paperwork I gave you. I've learned a lot through this process.
Jordan Emerson in California. Well, Jordan Emerson does not appear to be here. Tina Patton, who I think I saw her name on some of the submissions. Neither of them appear to be here. But that's we'll still hear from the complainant because it's a contested.
Right.
So just FYI, we will hear from complainant and then we'll move to Anderson.
Right. I think we should hear her presentation.
Great. So Ms. Stutz, since we seem to be on a
Yes,
roll,
ma'am.
everybody's last name. Am I getting yours right?
Stunts, like performing stunts.
Great. Okay. Ms. Stutz. You have 10 minutes.
Grooming stunts.
All
Okay.
right, whenever you're ready.
I don't need but a few. Okay. So I, as Ms. Morse found, Investigator Morse found, I participated in protected safety reports, but I failed to prove causation because there was a mountain of paperwork like this. Just because it had been ongoing, so I had quite a lot of information. So I want to help present causation. On 11/11, I told my district manager the date and time. I personally texted it to him. When now fired employee deliberately sprayed liquid into my personal station's electrical sockets. So he asked me at that time to not let him watch the videos before talking to HR, because I'd already talked to HR before about the girls in the salon coming into work high and then continuing to get high on cannabis, like the vape pens and the drinks and gummies and all that stuff. So I think that's super unsafe to be inebriated when you're at work with small animals and you have sharp implements. So they were pretty mad about that. And because of that, this is why this girl decided to either harm me, my equipment. I let my district leader know, and then nothing was found. But later the HR did find that the girl did what I said she did. They also found that another employee was bringing had a roach, and it was in front of my dog, and my dog could have eaten it and died, or been very sick, and I would have been liable because there's no cameras in the back. But the district leader closed the ethics point report that I did create on the 16th. He closed it saying that the DM and GM went through all this and there was no reason, they couldn't find anything. They couldn't find video proof. So basically on December 4th, it was a closed loop. Even though he's named in the report as supervisors that are involved, he told HR in the ethics point report to close the reports. There's no need to look at them. On 12/9, I applied for the salon leader position that I'd been doing already for more than a year. For instance, taking the salon leader phone calls, dealing with customers that are unhappy, finding ways to make them happy, scheduling orders. I've been doing all of that. They gave it to another person who was one of the perpetrators. She was given the title of salon leader. On 3/18, that same salon leader was on camera taking my personal equipment off camera, and then it was destroyed with super like a harsh chemical, and then I touched it and had to go to the doctor. I have that paperwork here too for chemical burns on my hands. And because I apologize, I have to go back. I'm so sorry. After the report that I gave about the girl spraying liquid into my electrical outlets, on the 16th, that report was in. On the 17th, I got a write-up with the same verbiage about, if you have personal equipment, take it to the back, that kind of stuff. So I was written up the day after. My equipment was destroyed 3/18. I was given a final write-up, and the investigators who found all this stuff out called it a clerical error, which is like, I don't know how you accidentally give someone a final write-up. That's a really big deal. But I was given a final write-up for them saying that I was unprofessional about how I handled my equipment being destroyed. And then also some off-camera safety violations. They're all bogus. And then on 4/12, I asked the CFO to help. I'm not going to say his name, but he did help me. And on the 15th, investigation began. Because of that investigation, the 8/8 employee was fired for the same thing that I said she was doing. She was fired for bringing a roach into the salon, and that's what my 8/8 report was about. The 11/11 report was also fired for misconduct. At this, the store leader was fired for not reporting this information, and then the district leader was also reprimanded, and he was actually given a non-clerical error final. Okay, so HR investigated, they got all that stuff. But they offered to reimburse me for my damaged equipment. But never did. They kind of did what they're doing now. They just failed to follow through. And then also, they offered me a transfer, but it would be within the same district leader. So I didn't feel safe. And they also said that they would do away with the write-ups, but by that time, 5/23, I just didn't feel like it was safe, so I had to constructively dismiss myself, and I wrote a letter and let them know. And she still said that I'm still able to work there, but I don't feel like that's possible under the same leadership. Although I've worked in Hawaii at the #1 salon out of all the salons as the district leader, as the leader, the salon leader and the mentor. So I've trained people and been this leader of salons in Hawaii, Wisconsin, Minnesota, Tennessee, and I was doing the same work in Maine right up until I reported the girls being high at work, and you just can't do that. It's unsafe. And the result of that was retaliation. I did not get the promotion that I'd been doing the work for. I was, people tried to hurt me and they hid it. And I think that's all I've got. And I would be happy to answer any questions. Again, Miss Angela, I'm so sorry for all the paperwork. I just kept everything. And then I've learned a lot. I can do PDFs now. Like I just make dogs pretty and people happy. So this was all new to me. And I'm so sorry for the box of paper. But hopefully this helps.
Commissioner questions? Yes, Commissioner David and then Commissioner O'Brien.
Yeah, I think Ms. Stuntz, that I understand the answer to this question that you were getting there. My question was, if all those people were fired and all that action was taken because it was inappropriate, violation of company policy, dangerous, all of those things, why didn't that cure the problem? And I think, am I hearing you say that there was still lack of support from the district manager or something, or?
Yes, the district manager,
Well,
as soon as that.
why do you say you still felt unsafe? Why did you feel unsafe?
Well, I would be under 3 levels of leadership that knew about this and then didn't report it. They actually saw the video, I was told, and then didn't help me.
So you're saying that there were 3 levels and it had to go higher than that to get the action to terminate those employees, and so you still felt unsupported by those lower levels of
Yes, sir. There was an
supervisors.
assistant store manager, and then the salon leader, and then the district manager.
Thank you.
I love Petco, just so you know. I've always loved Petco, and I still love Petco. I don't know what was wrong with this particular salon, but it's unsafe to do what they were doing, and I reported it. The main reason why is because there was a lady who saw one of the girls get smoking out in the car.
You answered my question that you still felt unsafe.
Oh, good.
And you gave me a reason why. Thank you.
Yes, sir.
Commissioner O'Brien.
Yeah, I was going to ask something like that, but also something small. I think I read it several times in here about reimbursing you for your equipment, your glued scissors.
Yes.
I mean, come on, that's pretty.
A little petty, yeah.
But are you saying that you did submit and you still haven't received any money?
Yes, ma'am. Yes, ma'am.
Okay, thank you.
I have so I don't think they assumed that I would take screenshots of everything, but Angela Morris, she's seen it. All the pictures that I have of the internal Workday communications, where I sent all this stuff to him. That's why they didn't know that I had the 8/8 report and every other one. Because they didn't think that I would take screenshots, but I saw the writing on the wall, to be honest. And so I just started documenting everything because I have a bad memory and I'm not going to remember. But I know pictures are worth 1,000 words. So I just started taking pictures of everything.
Thank
Too
you.
much, too much.
Any other commissioner questions for Ms. Stentz? Seeing none, we're going to move now to the investigator. Angela.
Hi, my name is Angela Morse. I
Hi.
was the investigator assigned to this case. No, I'm certainly sympathetic to Ms. Stuntz's experience. That was unpleasant at Petco. I just didn't find that there was any retaliation that was violative of the WPA. I thought this case was fairly straightforward in that there was no adverse action linked to the reports of cannabis use by coworkers. And when unsafe conditions were reported, such as cleaner being sprayed into an outlet, Petco did respond by firing 3 employees and disciplining another. So that is why I made the recommendation that I did. Yep.
Commissioner David.
Yes, good afternoon, Angela. Were you influenced by this argument of whether it was a violation of company policy or a violation of something more serious? In other words, if it was only company policy, that it therefore did not reach the level of discrimination under the statute?
Yeah, I did look into that because I was interested in the issue of the cannabis use and what's illegal and what isn't. But ultimately, I found that Ms. Stuntz did engage in protected activity because, at least to her, she thought that this was illegal activity. So,
okay, so you gave that issue to the complainant and found that it was protected activity. So why not a recommendation for reasonable grounds?
because Petco took appropriate responsive action based on these complaints with disciplining employees. And also, there was no adverse action here. Ms. Stuntz resigned. She was not fired. I don't think that there was intolerable working conditions. I think that Petco did respond. And in fact, some of the employees, I believe 2 of the employees that were fired were also supervisory employees who were basically fired because they did not do a good enough job investigating this whole issue. So to me, that looks like Petco is trying to perform an appropriate and thorough investigation by getting rid of those people who are not, participating to their full responsibility.
And when I was asking her question, she was saying that those people are still there, that there's still, that it had to go to such a high level that there's still supervisors there that were not responsive and not reactive, and that's part of creating the intolerable conditions that led her to resign.
The supervisors that were immediately involved in the investigation were disciplined or fired. There probably is other supervisors in the company that she finds problematic, but the ones that were directly involved in this investigation were dealt with appropriately.
Okay, thank you.
Any further questions for the investigator? Being none, we've heard from the parties and the investigator. We're looking for a motion. There is one proposed finding.
Is there any way I can interject one small thing?
At this point, we are done hearing from the parties, and the commissioners are going to vote on the report. Maybe we're just going to sit here for the rest of the afternoon. Maybe we're just going to stare at the wall for a while. I could start singing the Jeopardy theme song. That would move things along.
That always gets me. Yeah, I'll go ahead and move to accept the investigator's report as drafted. 1, there are no reasonable grounds to believe that Petco Auburn retaliated against Lindsay Stuntz for engaging in WPA or MHRA protected activity, and the complaint should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Second.
Moved and seconded. Any discussion?
Just one note for purposes of making sure it's entered into the record. You know, making an observation, of course, that Respondents Council did not appear today. I understand, Kent, that we don't have any indication from Respondents Council about why they failed to participate in this process today. So understanding that circumstances happen and things come up, I've said it before on the record, I'll say it again, failing to participate in this process, even where the respondent, for example, as in here, receives, you know, the report and there's a no reasonable grounds finding, is disrespectful to the complainant, to the commission, and to commission staff who spend a significant amount of time investigating these claims and doing justice in the state of Maine. So I'll encourage, I've encouraged it before, I'll encourage it again. It is imperative for council and representatives to participate in these proceedings.
Any further discussion?
Yeah, I find it a very close case. I want to congratulate Ms. Stuntz on a very clear presentation, and I'm sorry that she went through this. It is a close case. I also, as Attorney Sanders is offended by the lack of response by respondent. But I guess that on balance, I come down to the fact that they did respond, and that I can't find that there's unlawful discrimination, even though it was I understand what you went through and why you left. So I will vote for the motion.
Any further discussion? Seeing none. Motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
No.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable grounds. We will send a letter to the parties. Thank you for your participation. And that concludes the hearing agenda. So everybody will, you are not required to hang out with us anymore. We're going to deal with some tech stuff and get ourselves into some breakout rooms. Okay. So I need a motion to approve settlement in H230317 Berg v. Harbor Hill Associates et al.
So that's just settlement. Is that what you just said?
I thought that's what I was approving a settlement. Am I not?
Yes.
That's what I said. I said approve settlement.
It's not what I heard. I apologize.
I have a motion. Do I have a second?
Second.
All right. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
And I need a motion not to litigate H240334A and B, Edwards versus Tier et al.
So moved. And second.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. Thus endeth the meeting. We will see you all at the end of July. Have a happy sort of summer break. Ed, we'll see you on Zoom for the next few meetings, right?
Correct. Yeah, I'll still be up here. It's too
All
hot.
right.
Too hot down there for me.
Yeah, for me too. Maybe we'll start having the meetings from Canada.
Yeah.
You're welcome to come.
We're all going to descend on you up there by the ocean.
Absolutely.
Careful what you say, Ed.
Bye, Ed.
When you fall.
Yeah.
See you guys later. Bye.